or Haley. Good afternoon, everyone. Welcome to the Ways and Means Committee. It is February 2nd, and today we are hearing 19 bills. We have 10 bills on property tax issues and 9 on election law. So this will be only a few bills have a lot of people testifying, so be patient and hopefully we'll move through this very quickly. We first start with House Bill 441 from Delegate McKay, and welcome to everyone who's watching on YouTube. And if you're watching on YouTube and in our waiting room, make sure you sign in with your first and last name. And Delegate McKay, go ahead.
Okay, well, thank you, Madam Chair, Mr. Vice Chair, and members of the committee. If I may, I'd like to start with a little humor. There was 3 sons, and each of their sons gave their elderly mother a gift. One of the sons gave their mother a house so that she would be safe and debt-free. One son gave her a car so that she was able to come and go as she pleased. And the other son gave her a talking parrot so she would never be lonely. Now, a week went by and the mom called her sons to thank them. She said, son number 1, the house is just big and empty. And son number 2, the car is just so fast and so many buttons. But she said to son number 3, the chicken was delicious. Thank you. So House Bill 441 simply creates a work group led by SSTAT to study the feasibility of creating a unique Maryland identification number for each registered or licensed business in the state for the purpose of improving interagency information and data sharing for business entities, and makes it easier to recognize businesses entities registered by different state agencies. Now, why are we looking to do this? Well, you know that I'm a small business owner and that every business in Maryland is required to register with SSTAT, and most businesses are required to file business taxes, acquire licenses with the Department of Health, Labor, etc. When you register businesses with SSTAT or the department, it assigns you a business a unique identifier code or a SSTAT ID number. However, our comptroller's office and other state agencies do not recognize this code. For example, the comptroller only recognizes business entities via their employer identification number or their EIN number. This has become a major frustration for business owners, and if businesses are looking to be in good standing with SSTAT, but not in good standing, let's say, with the Department of Labor or the comptroller, those agencies can still, and they have in the past, ordered SSTAT to place your business in not good standing or forfeit statute or whatever the reason is. So as a small business owner, you call SSTAT to find out what the problem is. SSTAT has no idea why another agency ordered them to put a hold on your business or call the appropriate agency. You give them your SSTAT number, and the agency, of course, doesn't recognize it. And you have to go through the very archaic process for agencies to find your business. And then once the issue is resolved, the agency has to work with SSTAT to let them know that the business is back in compliance and lift the hold for SSTAT records. Unfortunately, this is very, very archaic and frustrating process, and it would be much easier if the state agencies could recognize one unique business identifier. The specified department listed in the bill will be added since there is a heavy involvement in licensing businesses as well as maintaining businesses' database. So in conclusion, let us get the conversation started by having these departments get in the same room, whether virtual, or let's see if they can come up with a solution. Also, I welcome any other agency that would like to be involved in the discussion. We have added MACO to bring some additional accountability because most county governments already recognize the SSTAT number and check with SSTAT for the status of business entities in their jurisdiction. So we felt that MACO could bring some expertise to the discussion. On a good note, there's a very minimal, if not no fiscal note, and the legislation has been cross-filed in the Senate. So I urge a favorable report for House Bill 441 And don't forget, the chicken was delicious, dear.
Delegate McKay, I'd like to challenge you to bring jokes that maybe are relevant to your particular bills, but thank you for that joke. Delegate Hornberger?
Thank you, Madam Chair. And, I want to congratulate you for the most common sense bill we've heard thus far. And I really like the intent. I'd also like to go one step further. I have a similar bill that would deal with this with making of campaign contributions. And as we know, many businesses can give to political entities. However, they're still subject to the cap of 6,000, even if they're multiple businesses owned by a single individual. So the question that I wanted to pose to you is there a way to tie this unique number that will be assigned to each business back to the ownership of said business? Or is it just an arbitrary number that's generated somewhere inside of state government?
Well, that's the beauty of this being a task force. Since I'm now presenting this and laying it to the committee, and if the committee decides that they want to change that, I welcome any kind of a change that would kill, I shouldn't say kill two birds with one stone, but definitely fix two issues. So if the committee so desired, that would be fine. I'm just willing here to work with you.
Okay, thanks so much. And thank you, Madam Chair.
Thank you, Delegate Hornberger. Next we have, Michael Higgs from SDAT, and then Corbett Webb as well from SDAT.
Good afternoon, and this is Michael Higgs with the Department of Assessments and Taxation. Thank you very much, Chair Kaiser and Vice Chair Washington, for having us. Corbett Webb is actually over in the Senate testifying on the cross-filed version of this bill at this very moment. So again, this bill creates a task force to determine a process by which SDAT, the Comptroller, Department of Labor, Office of the Secretary of State, and any other state agency that wants to discuss adopting a unique Maryland identification number for registering businesses and licenses. Our department fields about 1,000 inquiries from business customers every day and reviews about as many filings. And oftentimes customers are confused as to whether the identification number they need is the SDAT number, an EIN, a comptroller number, or some other ID issued by another state or local agency. When filings are submitted with SDAT, we frequently have to reject them because the customer puts in a different ID number in the SDAT ID number field. Having one unique Maryland identification number would make it significantly easier for these businesses to know that they are using the right number and make it easier for our department to inform customers what the right identification number is. We have a couple of examples of problems where this confusion has caused great stress for our customers, but more so lately it's been causing problems for state agencies. And a unique identification number would really go a long way to tearing down the walls that separate disparate and separate state agency functions. Recently, it was determined by the OLA audit that less than 40% of the businesses registered with the comptroller and SDAT can be matched up despite being part of the same universe because the comptroller and SDAT each have their own unique identifiers. Not only would having one unique identifier number simplify the process for Marylanders, but would also make it easier for agencies to interact with each other, cure audit findings, and improve transparency for the public. Better data sharing between agencies will also lead to collaborations that make it even easier to interact with state government and to do business in Maryland. Please also note that we have an amendment that will be introduced to remove the Department of Health from this task force as their top priority remains the COVID response. With that, I ask you to support this bill, and I'm happy to answer any questions that you guys have for SDAT.
Thank you. We have a question from Delegate Buckle.
Thank you, Madam Chair. And Delegate McKay's my district made 100% supportive of the bill and the idea. I guess my only question is a more theoretical one. Is this one of these situations? Why do we need legislation to have a government agency, bureaucratic agency, convene a work group among other government agencies to discuss a problem that they all recognize creates difficulties? And I'm not poo-pooing it at all. I'll support the legislation 100%. I'm just wondering, for my friend Michael Higgs, is this something that the government can just do on their own without a bill mandating them to do it? Or do you think if we don't do the bill, the separate government agencies just will refuse to meet with each other?
Sure, and we've had meetings about this very topic over the years. The problem is that agencies tend to get sidetracked with their own agendas and what's important, and putting out fires that prop up. And when it's important for us all to be meeting, in January about a topic, and then something pops up on the radar of one of the other agencies that becomes sort of an all hands on deck situation, then resources get diverted and the conversations tend to wind down. Having something that is a work group that gets mandated with a final report tends to focus everyone on the problem and lead to a little better solution, I think.
Okay, that's a fair response. Thank you.
Great question, Delegate Buckle. Any other questions for the delegate? I'm sorry, for Mr. Higgs? All right, thank you all. We're done with the hearing on House Bill 441. Delegate Mangione, House Bill 459.
Thank you, Madam Chair, and thank you, of course, members of the committee for hearing this bill, House Bill 459. Very important bill that deals with disabled active duty service members and disabled veterans and their surviving spouses. And it deals with the exemption from the property tax and other charges and refunds. And I'll try and be brief here before passing along. We have, I think, a couple panelists that joined us today, but to get started, refresh your memory, this bill was introduced last year before this session ended, of course, with coronavirus. And I want to highlight that this deals with the bravest of the brave here, our bravest warriors that have been deemed 100% service-connected, or who have a 100% service-connected disability. So, of course, making an incredible sacrifice for all of us, our country, our fellow Americans here. So HB 459, to sum it up, I mean, it's pretty straightforward when you get a chance to read it, but I'll just briefly summarize that it addresses a problem that results really from a prolonged processing time. Of course, it deals with on the federal side, with the VA and how long it takes to determine if, in fact, a veteran is entitled to 100% permanent disability status. And this is a process that literally can take years. So this bill, and hence, if it is passed, would allow the disabled veteran to be eligible to go back and to receive refunds on their real estate taxes that date back to the effective date of where their disability status was actually claimed. Now, again, it's pretty straightforward if you look back at it. I'll do a little, here's an important piece of information here that we can probably talk a little bit offline, Madam Chair, is that this is an identical bill that was passed last year in a bipartisan fashion on the Senate side, I think 46-0 with Senator Ellis. Now, there's a little bit of a difference here, but I have spoke with Senator Ellis, again, bipartisan, and with Mako as well. It changes from going back 5 years to 3 years. I guess we'll be hearing that when we get the blue book back to drop that. But again, pretty much the same exact bill. We cross-filed, again, 46-0 or against. So great bill, and I hope that you'll hear from some experts as well, and we'll be able to get this done this year. Thank you.
Thank you. Any questions for Delegate Mangione? All right, thank you, Delegate. We do have a few people signed up. Bob Marashek. I see that you're here.
Here I am.
And if you could speak up some, please.
Yes, can you hear me now? Okay. Hi, I'm Bob Marasek. I'm here in support of House Bill 459. And things I want to point out about the existing tax exemption, if you're not familiar with it, is that if you were to review this, you would see that the veteran is eligible once they are declared 100% service-connected disabled by the VA. And the veteran's surviving spouse would also be eligible for this exemption if the veteran applied for the exemption on the property the veteran owned. The surviving spouse could then later transfer this exemption to another property after the veteran's death. The issue with this current requirement for the exemption is that there are many, many veterans, as Delegate Mangione pointed out, that are finally declared 100% service connected disabled by the VA after they are deceased. The VA application process for disability benefits is very long. It takes years. Once a veteran files for disability, claims go through this review process that seems to be never ending. Many veterans will need the assistance of DAV, VFW, or an attorney who specializes in disability claims. If the veteran is declared 100% service-connected disabled after their death, they certainly cannot apply for the tax exemption. As a result, surviving spouses lose out on this exemption, even though the surviving spouse is eligible for VA benefits such as VA mortgage financing. So a few things to consider. Disabled vets have a diminished work capacity if they can work at all, and therefore their household income while they're alive is affected as such. Disability income is often well below what the veteran would earn if they were not disabled. The out-of-pocket medical expenses can often consume much of this disability income and even exceed it. A disabled vet and his family may, for one reason or another, not be in position to buy a home in the time frame laid out in the existing bill or the proposed bill, and I'll get to that in just a moment. Also, what if a disabled vet is relocating to Maryland from another state and too much time has elapsed since the date they became eligible? And so to give you a little bit of background on me and my own personal experience, I know these scenarios all too well. My father joined the U.S. Marines fresh out of high school, turning 18 while in boot camp and sent to Vietnam in February of '68. His time there was short, 5.5 months, as he was wounded in action in July of '68. In the next 48 years, my father had many medical issues caused by his time spent in Vietnam, requiring over 20 major surgeries. The last 15 years of his life, he was confined to his hospital bed, unable to walk. Despite all this, his disability claim was under review at the VA for many years. While he was declared various levels of disability by the VA, he was not declared 100% service-connected disabled until after his death.
Mr. Marischek, if the 3 minutes are up, can you just summarize and let us know your last sentence or two?
Sure. If you were to consider this bill, pass this bill, it would make a huge difference for veterans and their surviving spouses, for the exemption of property taxes.
Thank you. Thank you. Yosefi Seltzer?
Thank you, Madam Chair, and I appreciate your indulgence to allow me to enroll for testifying today. My name is Yosefi Seltzer. I'm an attorney at the JAG office at Fort Meade, and I'm speaking today in support of HB 459, which will benefit 100% permanently disabled veterans. I will note, as may have been alluded to earlier, the Senate version this year, SB 269, heard last week in Budget and Taxation, has a 3-year refund window, whereas the bill before you today has a 5-year refund window, and the two committees, assuming they are supportive, will have to reconcile, if it makes it through committee and chambers. This bill addresses the problem that results from lengthy processing times at the U.S. Department of Veterans Affairs. The VA reports it takes 12 to 18 months to review new appeals, and as long as 5 to 7 years when you appeal the initial decision. Some argue this bill would impose an undue cost burden on the state and local governments. This criticism is exaggerated and short-sighted. The fiscal note makes clear that a single refund of state property taxes would cost $370, and for 50 refunds, it would cost the state $18,500. For counties, it would cost $3,500, and for 50 refunds, it would cost the county approximately $175,000. As well, disabled veterans who feel welcomed are more inclined to remain in Maryland and use these refunds on the local economy, which will partially return to the state coffers in the form of sales taxes. Even more importantly, the property tax refund is a minimal cost compared to the priceless sacrifices paid by our veterans. Many of them have lost limbs, sight, and hearing, while others have suffered serious brain injuries, respiratory diseases, and mental health challenges. Often they live on fixed incomes because they cannot work and therefore depend upon the property tax refunds to help with living expenses, home health nurses, and handicap accessible home improvements. They are our friends, neighbors, and fellow parishioners and deserve our gratitude and respect. 5 years ago, President Obama vowed that we have to solve problems like long wait times at the VA, and we have to keep trimming the disability claims backlog. He added that we can never serve our veterans at quite the same that they served us, but we can try. This bill is a sensible way to try to help 100% disabled veterans by ensuring they are refunded real estate taxes they would never have owed if the VA was more efficient. It will also make Maryland more military friendly. Thank you, and I welcome your questions.
Thank you, Mr. Seltzer. Any questions for either of these two gentlemen? Delegate Barnes.
Thank you, Madam Chair. Do we have an idea of how many veterans in the state may qualify for this?
I don't have that number offhand. Yosefi, do you have any idea what that number may be? I think the fiscal note had some numbers on it. But I can try to get that back for you, Delegate. Try to find that out.
Yeah, I think he's looking. Mr. Social, did you have it?
Yeah, so the fiscal note indicates that for fiscal 2020, 12,386 property owners received a property tax exemption for being a disabled veteran. So that's the number that already qualified. And it talks about the associated revenue loss.
I don't want to hold it up, but if you can get that number back over to a Delegate Mangione, that would be helpful.
Sure, no problem, Delegate.
Thanks.
All right, thank you. Any other questions for these two gentlemen or for Delegate Mangione? All right, thank you. Thank you, Delegate Mangione. Thanks for joining us today.
Thank you all.
To members, we're done with the hearing on House Bill 459. We're moving on to House Bill 497. Delegate Boyce.
Good afternoon, and thank you so much. Please forgive me if I end up having a bit of a sneezing attack. My allergies are on 100 today, and I've taken everything I can, and it's not cooperating. So forgive me if I end up having to blow my nose. With that, good afternoon. Ways and Means Chair, Vice Chair, and committee members. For the record, I am Regina T. Boyce, delegate of the 43rd District, Baltimore City, here to present HB 497, Property Tax Credit, Urban Agricultural Property, Repeal of Repayment Requirement. So the bill repeals the requirement that the owner of property receiving the urban agricultural property tax repay all property taxes that would have been imposed if the property tax credits had not been granted should the property cease to be used for urban agricultural purposes, and applying, of course, that act to those taxable years. During the interim, I worked with Mid-Atlantic Farm Credit along with members of the Baltimore City Sustainability Commission, for which I am also a member, to discuss how we could increase farming access and opportunity in the city as well as other urban jurisdictions in the state. What are the barriers to access and agricultural success are the questions that I wanted to know. The review of legislation, city and state, found many costly barriers and red tape that unnecessarily increase the cost to farm, but also keep interested farmers from applying for the credit. One of those barriers was the repayment of taxes provision in state law that the city adopted in their legislation. A noted reason mentioned for a reason for cease operations of a farm, for instance, whether it was rural, suburban, or urban, was the lack of funding, and to request back taxes in full after ceasing farm operations due to lack of funding, or rather business failure, can create financial instability, and I would call debt-induced poverty. To date, there has been no discovery of a clawback provision with any tax credit. Providing farming access with less barriers is crucial for the social, economic, and environmental impact on urban communities, as well as communities that need and want the opportunity to farm. Thank you for your time and consideration of HB 497. I urge a favorable report.
Thanks, Delegate Boyce. Any questions for the Delegate? Delegate Barnes.
Thank you, Madam Chair. Delegate Boyce, do you know how many agricultural farms that received the tax credit that did not use it and had to give it back?
No, sir, not at all. And in researching this bill, one thing came up, the opposite. That's a great question. The opposite in Baltimore City is that most people who would otherwise farm are inclined not to because of that provision. So it kind of says, hey, if I fail, then then I get penalized for failing. When in actuality, we don't penalize businesses for failing when they get tax credit. They just lose the tax credit and you move on. So it was actually a deterrent. In Baltimore City, we only have, at the time, I think we only have 2 or 3, and we could have more, but there are other barriers. For instance, in Baltimore City, they require that you cannot have your, like in other farms, your actual home and property, farm property together. So they make folks do a subdivision of the property so that just the land and not the house is credited, which causes an additional financial burden to do that. So we're trying to work on that eventually, but we thought we would attack it from this end first. I hope that answered your question, sir.
Yes, ma'am. Thank you.
You're welcome.
Thank you, Delegate Barnes. Thank you, Delegate Boyce. Any other questions for Delegate Boyce? Thank you, Delegate Boyce. We do have 2 people signed up to testify, Kurt Fuchs and then Colby Ferguson. Mr. Fuchs.
Thank you, Madam Chair, members of the committee. My name is Kurt Fuchs, here today on behalf of Mid-Atlantic Farm Credit. Farm Credit is headquartered in Westminster, Maryland. We are a member-owned cooperative that supports rural communities and agriculture by providing reliable, consistent credit and financial services in good times and bad. We have a loan portfolio just shy of $2.9 billion in loans outstanding to over 11,500 member owners across our 5-state footprint. And that makes us one of the largest agricultural lenders on the East Coast. And to be clear, we serve all from multi-million-dollar business operations all the way down to a couple thousand square foot market garden and every single thing in between that you can think of. And I appreciate the opportunity to support House Bill 497. I certainly thank Delegate Boyce's efforts to investigate what are some of the stumbling blocks and roadblocks to urban ag expansion in Maryland. And because of that, support 497. She already talked about what the bill does. We do think that it is an impediment to the provision's ability to do good. This clawback provision is something that people are likely to shy away from because of it. And you have my written testimony, so I'll keep my remarks brief. But I did want to highlight one of the things that was really highlighted over the past year during the pandemic is how vulnerable our supply chains and certainly how many of our communities can become food insecure extremely quickly. I think this bill does a good thing for supporting urban ag production, local food production, and the more that we can do to build resiliency in our food production across the state, both in our urban and suburban areas and throughout our rural areas, the better we are and the better we can withstand future impacts like the pandemic. With that, appreciate the opportunity, would urge a favorable report, and happy to entertain any questions that you might have.
Thank you. We'll see if there's any questions after both of you speak. Mr. Ferguson.
Thank you, Madam Chair, members of the committee. Colby Ferguson on behalf of Maryland Farm Bureau. And I'm not going to go over the bill again. I think it's been explained very simply. It just removes that section of the clawback clause. And honestly, if you look at the fiscal note, only about 3 or 4 projects have moved forward, and which is kind of disappointing. And I think from what we're hearing, this clawback is one of the main deterrents. They're worried that it's already a risky business to get into urban agriculture, particularly on the production side. And if all of a sudden, if it doesn't work, to add insult to injury, they would have to pay back taxes on top of that. So we really do see this as an opportunity. And when you're looking at several $100s of back taxes versus several $1,000s that maybe a developer might want to take and do, I don't see there's enough value for a developer to take advantage of this and have to go through the process of doing a production ag on this urban area. So I understand the reason why it was put in there initially, but after seeing the project in place, I think that deterrent is really affecting the farmers that want to utilize this opportunity versus trying to keep developers at bay. So with that, we would encourage a favorable report, and hopefully we can get some more urban farming in Baltimore.
Thank you so much, Mr. Ferguson. Any questions for either gentleman? All right, thank you both. Seeing no questions, thank you, Delegate Boyce. We'll see you later. We're going to move on to House Bill 591. Delegate Watson.
Hi, good afternoon, Madam Chair and members of Ways and Means, and Delegate Ron Watson, Legislative District 23B. Here to introduce House Bill 705. This bill is pretty simple. It seeks to expand the eligibility criteria of property tax exemption for specified disabled veterans and surviving spouses of veterans to include veterans with at least an 80% service-connected disability. Under the current law, veterans must have 100% service-connected disability to be eligible for property tax exemption. This is the same bill I introduced to this committee last year. The Senate version passed 45 to none. And many of the comments that Delegate Mangione had in his bill are valid, so I won't belabor the issue. We currently have in our state 371,164 veterans, and of those, a little over 83,000 are classified as disabled. In my home county, Prince George's, we have a substantial amount of residents from the veteran community. Of the 56,000 total veterans in Prince George's County, a little over 16,000 of them are classified as disabled. We think that the state of Maryland can do a little bit more to protect those who served our community, and I ask for a favorable report on House Bill 591.
Thank you, Delegate Watson. Any questions for Delegate Watson? Delegate Rose.
Thank you, Madam Chair, and thank you, Delegate Watson, for a great bill. I was just making notes, and I couldn't write fast enough. You said about 371,000 veterans in the state of Maryland. How many disabled?
83,730 as of 2020.
Thank you very much, and thank you for the bill.
Thank you.
All right, any other questions? All right, seeing none, thank you, Delegate Watson. We do have one person signed up on this bill, Kevin Canale from MACO.
Good afternoon, Madam Chair, members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in opposition to House Bill 591. We certainly appreciate and understand the intent of this legislation, but counties are concerned with the carryover fiscal effects of this bill, and we prefer approaches that provide local autonomy to determine the best way to provide these incentives rather than those that mandate reductions in local revenue sources. In fact, several counties do go above and beyond for our veterans, rightfully so. And we provide these kind of credits, not necessarily for just a 100% service-connected disability, but under this bill, according to the fiscal note, counties could lose up to $10.5 million of their most reliable revenue source per annum. So this is revenue that's sorely needed to fund schools, public health, public safety, infrastructure, other essential services. So as the focus shifts to restoring our state and local economies in a manner that is safe, equitable, and prosperous for all, counties are happy and welcome the opportunity to work with this committee to develop targeted or optional tools to create these kind of incentives, but we do resist state mandated changes that preclude local input. So with that, we'd ask for an unfavorable report on House Bill 591.
Thank you, Mr. Canale. Any questions? All right. Thank you very much. Thanks for joining us. Well, I guess you're coming back on a later bill. We're done with the hearing on House Bill 591. Delegate Hill, House Bill 610.
Good afternoon, Madam Chair. Thank you very much. Delegate Terry Hill, for the record, I'm here to present House Bill 610, which is a bill that came out of the Attorney General's Access to Justice Task Force. And the problem that we are attempting to resolve with this is one of the things we saw particularly come to the fore in the COVID emergency is that when we had families of limited means who were sharing a household with multi-generations, and the owner of the household had a homeowner's tax credit on the home. If that person died and the surviving family members residing in the home would have qualified for the homeowner's tax credit upon inheriting the property. If they couldn't afford to go through probate, they would actually lose the home. So we're seeing families that are being forced into losing the family home, into homelessness, not because they wouldn't qualify for the tax credit once they became owners, but because they couldn't afford to become homeowners once the relative who owned the house died. And so what this bill simply does is it allows for, and with an amendment that Mr. Chance will explain, it allows for the home to be passed on, or the credit to be passed on pre-probate or during probate, so that they can use the house as the primary asset to allow them to afford to go through the process they need to go through to finish dealing with the necessary things that are legally required. And I hope that was clear, but if it was not, Mr. Chance will explain. So if I could give him the balance of my time, I'd appreciate it.
We don't share the balance of our time.
Darn it. Do you want me to talk longer, Madam Chair? I can go.
No, not at all.
Well, I hope that you'll refer to my written testimony. It goes into
concise testimony is our favorite, and our second favorite thing is seeing kids, as Delegate Plakovich-Carr just had her son there for a moment. Delegate Long does have a question for you, Delegate Hill.
Sure.
Thank you, Madam Chair. I'm just curious if, I understand the situation, if it was set up in a life estate where actually the homeowner, once they passed, would automatically go to that family member, would they be eligible for the homestead property tax credit?
I think you still have to qualify for the tax credit by what criteria are set up. So just because you get it, so the people would still have to qualify. It doesn't change the qualifications. So we're really talking about folks who, by virtue of their economic situation, would qualify, but they have to first inherit the home too. And so if they don't inherit the home with the benefits of the tax credit being given, they're still having to pay for taxes on a house with credit. Does that help? So if they were given the tax credit that they're entitled to, they wouldn't be having to pay the taxes at the same level. Because we don't give it to them before probate or during probate, they're hit with a tax bill that they can't afford. They lose the house, and had they gone through that other process, they would have been given the credit. So in terms, yeah.
Okay, I guess this would be for legal counsel. Given the circumstances, if the houses were set up with a life estate, they would automatically inherit the property. Am I correct?
I think you'll talk to Mr. Chance after his testimony, because he's the attorney.
Okay, that's fine.
Okay.
Thank you, Delegate Long. Thank you for those questions. Any other questions for Delegate Hill? All right, thank you, Delegate. We will move on to Timothy Chance, who Delegate Hill referenced.
All right, thank you, Madam Chair and distinguished members of the committee. Thank you for the opportunity to testify today. So my name is Timothy Chance. I am the Tangled Title Attorney with Maryland Volunteer Lawyer Service. I assist with our My Home, My Deed, My Legacy project. And as part of this project, I encounter many clients facing economic barriers, such as significant tax bills, which makes it impossible for them to transfer their property. And I'm here today to respectfully give you my reasons to support House Bill 610. So in the My Home, My Deed, My Legacy project, MVLS provides homeowner clinics to help Marylanders stabilize their homes and secure critically important resources, including the tax credit for the long-term ability to remain in their homes. Additionally, we provide continuing direct representation, both by volunteer attorneys and myself, to clients navigating the probate process. Many of these clients are the surviving relatives of deceased homeowners. Oftentimes, the home is the only asset. Our clients live in the homes and are essentially the de facto owners, but these homes are still titled in the deceased names. So they must go through probate to retitle the deed. Probate is a costly and time-consuming process. And in addition to the fees associated with probate, our clients must remain current on the property taxes in order to eventually record the new deed. A homeowner who is facing financial hardship can greatly benefit from the tax credit. Unfortunately, an individual is only eligible for the credit if they are named on the deed. Without access to the credit, many of our clients are at risk of losing their homes. I want to briefly talk about a client of mine who's dealing with this issue right now. So Lucille has lived in her home in St. Mary's County since 2011. The property is titled solely in her husband's name. And in 2012, he took out a reverse mortgage on the property. In 2019, Lucille's husband died. Lucille promptly opened an estate, and as the surviving spouse, she is able to stay in the home as long as she stays current on the property taxes. Unfortunately, the annual property taxes for the home are in excess of $4,000, and Lucille only has an annual income of $16,000 and is unable to pay that without significant assistance. If she had access to the tax credit, the bill would be around $420, a much more feasible amount. But because she cannot access that credit, she's at risk of losing her home. Unfortunately, the situation is all too common. I want to draw your attention to my written testimony, which highlights another client in Baltimore City dealing with a very similar issue. Without the ability to access this credit, many of our families are facing hardship financially, and they face issues that can and do lead to homelessness. I'm deeply committed to the stabilization of our communities, why I support House Bill 610. Thank you so much.
Thank you so very much. Any questions for Mr. Chance? All right, seeing none, we have Kevin Canale signed up in opposition to the bill.
Good afternoon, Madam Chair. Kevin Canale here on behalf of the Maryland Association of Counties. In opposition to House Bill 610, I will say right off the bat, the way this bill has been described by Delegate Hill is opposite of what the fiscal note reads and the way we understand the bill. I know there was mention of an amendment. I can tell you that if the way this bill was described, if that's the intent of the bill, we have no issue with this bill. What we're trying to make sure is that we have a number of counties that provide actually a supplemental credit at the local level. And, the fiscal note notes that this could have an effect on those supplemental credits without local input. Again, the way this has been described by Delegate Hill and by the advocates here is certainly not something we'd be concerned with. Our concern was that this would automatically transfer to a surviving family member. Right now, it's just a surviving spouse who is unmarried, who's eligible to receive a transfer of this credit. So I'm interested to see if there's an amendment here. I think that makes sense. But I'm very willing to work with the delegate and with the committee. And I think based on the way this has been described, we'd be willing to drop our opposition to this bill. So I appreciate the explanation and I'm open to any questions.
Thank you, Mr. Canale. Any questions? All right. Thank you so much. Thank you, Delegate Hill. Good to see you.
Thank you. Good to see you. And Mr. Canale, please, we'll be in contact and we'll work to try and make sure that our amendment addresses your concerns.
Absolutely. Thank you, Delegate Hill.
All right, we have a local Montgomery County bill, House Bill 571, and Delegate Sarah Love will be presenting this.
Thank you, Madam Chair. Good afternoon, everyone. It's wonderful to be here. I don't often have the privilege of addressing Ways and Means. So yes, as Chair Kaiser said, I am Delegate Sarah Love here on behalf of the Montgomery County delegation to present a local bill, HB 571. This bill grants enabling authority to Montgomery County to enact a local law that allows abatement of overdue property taxes for any taxable year beginning on or after July 1, 2018 for a dwelling owned by a disabled active duty service member, disabled veteran, or surviving spouse. Okay, in short, because that was the technical description, in 2019, the General Assembly passed a bill allowing disabled active duty service members to be added to disabled veterans and surviving spouses as eligible to apply for an abatement of property tax for tax years beginning after June 30th, 2019. That date should have been 2018. So this bill makes the provision of that law retroactive to 2018. As Montgomery County Council member Andrew Friedson said when presenting this bill to our delegation, it doesn't benefit a lot of people, but for those people it benefits them a lot. This bill was voted out of the delegation committee yesterday, and it will be voted on by the full delegation on Friday, where I suspect it will receive unanimous support. So for those reasons, on behalf of the Montgomery County delegation, I respectfully request a favorable report on HB 571.
Thank you, Delegate Love, on behalf of the county. Any questions? Thank you very much.
All right, thank you.
All right, members, I should have announced this earlier. Today is Bob Longpalooza with 4 bills related to property taxes. Delegate Long, I have your bills in numerical order, if that pleases you, or if you wanted a different order. All right, we need you to unmute. And then the mic is yours.
Do I have to tell a joke?
You do not have to tell a joke, but if you do, make one funnier than my case.
All right, well, I'm not going to go there. The first bill is a Baltimore County delegation bill. It's HB, for the record, Delegate Bob Long for HB 570. It's the Baltimore County homestead property tax credit and lead, notification of lead let me start over again. Homestead property tax credit notice of lead registration and code compliance. This is basically a pilot program we're trying to get. We want to do in the 6th district, in my district, because we found that there's several homeowners. There have been several homeowners that are eligible for a homestead property tax credit. They're not getting it. So this would send out a notice. One part of this bill would send out a notice to property owners that are not receiving it to receive a notice that they are eligible. The other part of this bill, and I believe we've heard this bill before, would actually target properties that are being used as a rental property, but registered as owner occupant. We've had several incidences where we found out we've had landlords that are not complying with local laws and also lead paint registration. And, as being a landlord and representing landlords throughout Baltimore County, we play by the rules, and everyone should play by the rules. Anyway, this is to find out whether or not, it's to put them on notification that they have to register the property, and also it's a twofold, actually, to also notify property owners that's not receiving the tax credit they could possibly be eligible for it. And I would ask for a favorable vote for HB 570.
Thank you, Delegate Long, and to members again, House Bill 570. Any questions for Delegate Long? 1 second. All right, Delegate, I'm not seeing any questions. Which bill would you like to take up next?
That's good. For the record, Delegate Bob Long for HB 557. It's a homestead property tax credit calculation for credit for dwellings for purchases by first-time home buyers. What this would do, if you're owner occupant, you get the homestead property tax credit. What this would do would actually give the credit forwarded to the new homeowner for a period of 5 years. So instead of coming in getting hit with the full tax assessment, it would come in at over a 5-year period. This would open up, I believe, the market for first-time home buyers, which we want to make sure people are able to buy a house. So this is not a bill that would actually cost the county any money until it actually would help, because they could actually bring in more home buyers, and the property assessment would go up to the assessed value after 5 years. And as being a real estate broker, we need to do everything we possibly can to help out our homeowners get into their first-time home. And for that, I would ask for a favorable vote for HB 557.
Thank you, Delegate. Any questions? Delegate Barnes.
Thank you, Madam Chair. Delegate Long, you said that you referenced the county. Is this a local bill?
No, this is a statewide bill.
Okay. All right, thank you.
All right, any other questions? All right, thank you, Delegate Long. Next bill.
For the record, Delegate Bob Long for HB 559, Homestead Property Tax Credit Supplement. I'm sure you guys, I'm sure you've heard this bill before, talking about people with lower income under $60,000 available to get a homestead property tax credit. This will raise the limit up to, let me get the record here just to make sure. We'll raise the limit for people to be eligible for the tax credit supplement. When this bill was actually introduced back in 2006, it is not reflected, there's been no reflection to the current inflation rate. So in 2006, $50,000 or $60,000 is not the same money as it is today. And given the pandemic that we have people that have dual incomes that are buying homes, and someone's lost their job, laid off because of the COVID. This would help give them a little bit of cushion, put a safety net up to help people out. Last thing we want to do is see people lose their home for property tax credit and property taxes. So anything we can do to help people stay in their homes, that's what we're here to do. And like I said, it hasn't been raised since 2006. And for that reason, that's why we're asking to bring the qualification up to 72,000. And I would ask for a favorable vote for HB 559.
Thank you, Delegate Barnes. Delegate Long.
That's all right.
Any questions for Delegate Long? All right, thank you, Delegate. And now your last bill?
Yes, ma'am. For the record, Delegate Bob Long here on HB 573, Baltimore County overdue property tax waiver, interest and penalties. Basically, this would waiver any penalties or interest for property taxes that are not paid, they're in arrears, to help property owners. If you're already upside down, you can't afford to pay your property taxes. Let's not keep adding interest and penalties to it. Let's put a moratorium on it. I'll tell you how long it's for. I believe it's for 2 years. Yes, it's for 2 years. And, with the pandemic, again, we have property owners that are struggling to keep in their homes, and we want to make sure that we don't keep penalizing them or charging them more interest on property taxes they can't already pay. Thank you, Madam Chair, and I would ask for a favorable vote. Thank you.
Any questions for Delegate Long? And that was House Bill 573.
Yes, ma'am.
Seeing none, we're done with the hearing on House Bill 573. And I do have to apologize back to, back to 557 for a moment. I skipped over Kevin Canale, who was signed up to testify. Mr. Canale, are you still here?
I am. Thank you, Madam Chair. Is it okay? Would you like me to go ahead now?
Yes, please. My bad. I apologize.
No worries at all. Thank you very much. Madam Chair, members of the committee, Kevin Canale here on behalf of the Maryland Association of Counties in opposition to House Bill 557. As you heard, this bill essentially opens up the property tax savings under the homestead property tax credit to be transferable to first-time Maryland homebuyers. This dramatically undermines the longstanding policy purpose of that credit, which is to ensure stability in tax bills after the time of purchase. Counties oppose this bill because it compromises the basic nature of the credit and it threatens a severe fiscal impact to county budgets. It's important to note that nearly every county has exercised their authority to lower these caps, providing security to homeowners beyond what is required by the state. However, if this credit were to be expanded to all homes transferred to new homeowners, counties could lose up to $12.5 million of their most reliable revenue source by fiscal 25, according to the fiscal note. We could be forced to eliminate the expansions of the homestead property tax credit, or where feasible, or potentially cut budgets for schools, public health, public safety, and other essential public services. I also want to point out that the bill's fiscal note is based on 1 year of sales data, and that several factors can impact the year-to-year revenue effect for the bill. For example, for the fiscal note on House Bill 1445 of 2018, which is an earlier introduction of this bill, that used data from fiscal 2017, and it projected local property tax revenue losses of $85 million by fiscal 2023. So with that, you have my written testimony. I don't want to belabor the points, but in summary, this bill subverts the main policy goal of the longstanding and successful homeowners property tax program, and it potentially costs counties millions of dollars in needed revenue. We understand that we have to provide incentives for first-time homebuyers. This isn't the way to do it, and we'd ask for an unfavorable report on House Bill 557.
Thank you, Mr. Canale. And again, everyone, that was back on House Bill 577. Any other questions? Any questions from members? All right, thank you all very much. We're done with the hearing on 557 for the second time. To members, we have finished the 10 property tax bills in less than an hour. I hope that the 9 election law bills can be done in maybe 2 hours. So we'll see how that goes. The next bill we have is a Montgomery County local bill. And if if I knew it was going to be a member of our committee presenting it, I might have delayed it a bit. Like to put all of us at the end because we know where to find you a lot easier. Anyway, House Bill 433, Delegate Lutke.
Thank you, Madam Chair, members of the committee. House Bill 433 is a relatively straightforward local bill. Localities have been authorized under state law to provide for public financing of campaigns for county executives and county council members. Montgomery County implemented them in our last election. This local bill would simply allow Montgomery County to expand their system to include 4 additional races in addition to county executive and county council. Those 4 additional races are the races for state's attorney, sheriff, register of wills, and clerk of the court. It's been supported by the Montgomery County delegation as well as by the county executive and county council, and I would ask the committee for a favorable report.
What very concise testimony, Delegate Lutke. You win for today. Any questions for Delegate Lutke? All right, thank you. We're done with the hearing on House Bill 433. Delegate Henson, House Bill 450.
Thank you, Madam Chairwoman, Vice Chair Washington, and members of the Ways and Means Committee. Thank you for the opportunity to present House Bill 450, Election Law Polling Sites Firearms Prohibition, with the intent of securing your favorable vote. This bill will simply prohibit people from bringing firearms within 100 feet of polling sites during an election, excluding, of course, law enforcement officers and security guards that are on duty. There are 10 other states and Washington, D.C. that have this law already: Arizona, California, Florida, Georgia, Louisiana, Mississippi, Missouri, Ohio, South Carolina, and Texas. In short, guns have no place at an election site. We've seen the limits of safety and security tested in elections. House Bill 450 will take a productive step towards giving voters ease and confidence in their safety while casting their votes. Thank you. I hope to have your favorable support.
All right. We'll start with some questions. Delegate Butler.
Yeah, thank you, Madam Chair. The question I have, has this been a problem here in the state of Maryland where we've had people show up with guns at all?
Thank you, Delegate, for your question. One of the persons signed up to testify in support is a constituent of mine, and this was brought to me by a constituent that had this concern.
Yeah, but my question is that it may be a concern, but my question is, do we have incidences of this happening on election day that people are doing this?
Thank you, Delegate Butler. I think what's important to constituents is not only incidences, but the appearance of safety. We want people to cast their votes without the fear of having to wonder. We don't want to shake people down and figure out if a person has a gun. We want to make an affirmative statement as a state that we don't want guns at our election sites. And we want constituents to walk in with the safety and security of knowing that that's the law in the state of Maryland.
All right. Any follow-up questions, Delegate Butler? Delegate Long?
Thank you, Madam Chair. I have a question. What about persons that are allowed to carry legally with a concealed carry permit? Do you think they shouldn't be allowed to carry while on the premises?
Thank you for that question, Delegate Long. The answer to that is yes.
I'm sorry. So you're saying they should be allowed to, or no, they should not be?
I thought that you said, should they not be allowed to? The answer to that question is they should not be allowed to lawfully carry unless they are a law enforcement officer or a security guard and they are on duty. That's why we have our law enforcement and security there, and they are armed and they're there to keep the peace and to keep everyone safe.
Okay, last question. What about someone that's had their life threatened or had death threats, and that's the reason why they have a concealed wear permit? You think that knowing that this legislation passed, that now if that person that wants to do harm to whoever it is would know, hey, they can't carry their weapons while they're out at the polling place working, whatever, whatever. I'm concerned about this because, you're already limited to where you can carry a weapon. And given the fact that now you're saying that you can't completely. I don't understand why we're trying to fix something that I don't see a problem. I understand if somebody's walking around with a gun strapped to their back, I agree 100%. We're talking about law-abiding citizens that went through rigorous background checks, training, and did a lot of things to get a concealed wear permit. And you have to have a good substantial reason to get one. You just don't give it out to anyone. And that's, and would you think that you would still think that they shouldn't wear a gun or have a gun if it's concealed, no one sees it?
That's correct. We don't want our poll workers or anybody that's there to cast their vote to have to make those types of decisions. That's why we put our confidence in our law enforcement officers and other persons that are trained in armed security guards that are there to keep our election safe. We don't want to have the average citizen having to make those kinds of judgment calls, certainly not in a polling site where people are casting their votes.
One last thing. All the polls that I've worked at, I very seldom see an armed police officer there. Very seldom do you see an armed police officer. Thank you.
Thank you.
Thank you. Any other questions? Seeing none, thank you very much. We'll go to the speakers list for this bill. Next we'll have up is Jared Littman and Lauren Klein. Jared, you can start.
Thank you very much. My name is Jared Littman. I am a business owner. I own K&B True Value in Annapolis, Maryland. I'm also the former alderman for Ward 5 of Annapolis. And I appreciate the opportunity to address the Ways and Means Committee. I'm very concerned about protecting our ability to have free and fair elections, and I believe that encountering a civilian with a gun at a polling location is threatening. And I believe that the only purpose of bringing a gun to a polling location by a civilian is for intimidation. In 2020, we saw unprecedented waves of heavily armed protesters and breaches of previously accepted norms of civil society. This happened in places like Fairfax, Virginia, where the former president's supporters disrupted a line outside an early voting center, and that's according to the New York Times. It opened our eyes to the need to be more proactive, to think about what we need to do to protect our democratic institutions. Nothing is more fundamental to our democracy than having the right and ability to vote in free and fair elections without intimidation by others. Armed intimidation at the polls is voter suppression, plain and simple. It is an undemocratic form of harassment that should be unlawful and is an affront to our safety as well as the integrity of America's free and fair elections. Elected officials of all parties must condemn these harassment efforts and join gun violence prevention advocates and voting rights advocates in passing legislation prohibiting carrying guns at the polls to uphold the integrity of our elections and democracy. This is the time to join 6 other states that already have laws prohibiting guns at polling places, including Arizona, California, Florida, Georgia, Louisiana, and Texas. I thank you for your time and consideration of this legislation.
Thank you. Next we'll have Lauren Klein and then Mindy Landau. And then we'll take a couple questions.
Good afternoon, Chair Kaiser, Vice Chair Washington, and members of the committee. My name is Lauren Klein. I'm co-founder of the Montgomery County chapter of the Brady Campaign to Prevent Gun Violence. I'm also a resident of Bethesda, and I've lived in Montgomery County for over 30 years. As some of you may know, the Brady Campaign is named for Ronald Reagan's press secretary, Jim Brady, who suffered a gunshot to the head during an assassination attempt on President Reagan. I'm here to speak in support of House Bill 450, which prohibits the carrying of firearms at polling places. Thank you for giving me this opportunity to speak on this legislation. We respect the rights of gun owners to have and to carry firearms as guaranteed by the Second Amendment. That right, however, must be exercised so as not to infringe on the constitutional rights of others, including the right to vote. Particularly in our current political climate, it is far more likely that voters and poll workers will be intimidated by weapons carried in a polling place than it is that a firearm will be needed for some legitimate purpose, such as self-defense. The right of all eligible voters to exercise their privilege is one of the sacred principles upon which our democracy is based. All voters should be able to do so without the fear of intimidation. Voter intimidation is illegal. It can be very difficult to monitor if individuals in a polling place have weapons. The mere presence of firearms can instinctively provoke fear, particularly among survivors of gun violence. Armed intimidation is voter suppression, And the only way to assure there is not such intimidation is to restrict firearms from polling places. No voter should have to choose to be confronted with lethal weapons simply to exercise their right to vote. As a country, much work has been done in the last 100 years to ensure that democracy, as represented by the right to vote, is accessible by all, regardless of their race, their socioeconomic class, or disability. Unfortunately, there are still those who will show up at a polling place with firearms, not because those firearms are needed for protection, but to intimidate classes of voters, particularly minorities, from voting. We should not allow that to happen, and prohibiting firearms in polling places is necessary to assure that it does not. Thank you for your time. Brady, Maryland strongly supports this bill for the reasons I've given, and we appreciate the efforts of Delegate Henson in introducing this bill to make our polling places welcoming to all voters and our communities safer.
Thank you. Mindy Landau.
Good afternoon. My name is Mindy Landau. I'm a resident of Potomac, Maryland, and I've lived and worked here as a federal employee, now retired, for 40 years. I'm also on the State Executive Committee of Brady United Against Gun Violence. Thank you to the Chair, Delegate Ann Kaiser, and Vice Chair, Delegate Alonzo Washington, for this opportunity to speak. There is absolutely no reason why firearms should be allowed at polling places. When I perform my civic duty by voting, I don't want to feel pressured, intimidated, or afraid because others are carrying guns. Firearms can provoke strong fear and emotion in many individuals, especially survivors of gun violence. Voting polls are a place where we can peacefully disagree for the candidates by voting for the candidates we support, and I emphasize peacefully. Polling places are sacred to our democracy and the right of every individual to participate freely without threat. Fortunately, the November election was not marred by gun violence. Most gun owners are responsible, and few would even think to take a gun with them to a polling place. But some Trump supporters showed up to polling places with guns, while private militias and other groups have displayed arms and leveled threats at lawmakers. The stakes are high. Even one violent incident could not only claim lives, but deter countless would-be voters from venturing to polling places in the future. Such harms to our democracy by the chilling effect that guns can have on others' constitutional interests are often overlooked in the gun debate, which tends to focus exclusively on body counts. But gun laws are designed to do more than protect physical safety alone. They can and do help preserve public order and the freedom of others to assemble, speak, worship, and vote without intimidation. There are already too many impediments to voting. Fear of intimidation with a gun is one that we can easily eliminate. Let's call it what it is. Armed intimidation is voter suppression, and suppression is not what Maryland is about. The Virginia General Assembly just passed a similar bill. This is why Brady United Against Gun Violence appreciates and strongly supports Delegate Henson's bill. Thank you.
Thank you. Questions, Delegate Hornberger.
Yes, so this was kind of touched on there at the beginning, and either the bill sponsor or the advocates can answer the question. There was reference made to law enforcement being present, or a secured guard, or some sort of police presence at the voter sites. If the bill seeks for, let's say, folks that have a concealed carry permit, maybe they're under duress or they've had someone assault them in the past, the likelihood of bumping into that person or seeing that person at a precinct is highly likely, because folks tend to live in the same proximity of each other. So my question to the bill sponsor is, if you are forcing the folks to waive this right to have this protection while they're engaging in voting, would you be open to an amendment that would mandate that a police officer be present at all times at all polling locations to kind of maintain that peace that you made reference to earlier in the bill?
Delegate Henson, you want to answer that? You don't have to.
Thank you, Mr. Chairman. No, I would not. Thank you.
Okay, thank you.
Thank you. Any other questions? Seeing none, thank you all. Let's go to the next group of speakers. We have Kelsey Rogers, Molly Voigt. Yeah, Kelsey Rogers and Molly Voigt, and then we'll get into the unfavorables. Kelsey. Ms. Rogers?
I don't think Kelsey's going to be able to make it.
Okay, well, Ms. Voigt?
Thank you, Mr. Chairman and members of the committee. And thank you to Delegate Henson for sponsoring this bill. My name is Molly Voigt. I'm representing Giffords, the gun violence prevention organization founded by former Congresswoman and gun violence survivor Gabby Giffords. We're here in support of this bill today, which, as you've heard previously, would prohibit the carrying or display of a firearm within 100 feet of a polling place during an election. Currently, several states in the District of Columbia place similar restrictions, and this bill would allow Maryland to join that list. During the 2020 election, Americans were encouraged by baseless claims of widespread voter fraud and threatened to turn up at the polls with their guns to safeguard the vote. Thankfully, this largely did not come to pass, yet after it became apparent that President Trump had lost the election, armed individuals began to descend on locations where the vote was being counted, threatening election workers and others tasked with conducting America's sacred, free, and fair elections. While the scales and tactics we witnessed in 2020 were unprecedented, the use of guns to chill free speech and other constitutional activities and intimidate voters is nothing new. In particular, guns at the polls have been used to disenfranchise Black and Brown Americans who are disproportionately impacted by gun violence. In 2021 and beyond, after Americans have now witnessed armed Trump supporters mount an attack of insurrection on the US Capitol, threatening the lives of federal elected officials, the presence of guns in and around areas where elections and democratic activities are taking place will likely be seen as an even greater threat. Guns have no place in the polls and can only serve to harm, not help, the cause of democracy. For these reasons, we urge a favorable report on HB 450. Thank you very much.
All right, any questions? Seeing none, thank you very much. We're going to call the speakers who are in opposition to the bill. We have first James Ebling, and then Mark Panek. James?
Hi, can you see me? I'm sorry.
There we go. Yep, we can see you. Go ahead.
Thank you. I am first of all, thank you for allowing me to be here, Madam Chairman, Mr. Vice Chair, and members of the committee. I am actually a Maryland wear and carry permit holder, and I usually use an early polling place that, unlike schools, current law doesn't prohibit carrying a firearm on that. If this bill should become law, then it would make it pretty difficult for me to stop and vote on the way home from work. My schedule makes it pretty hard to get to the polling place for my regular polling place. So that's why I early vote. And I know some of the people in support of this bill had mentioned that they can't see any reason why somebody would bring a gun to a polling place other than to intimidate people. But when I carry my gun, it's concealed. Nobody ever knows that I have it. And I don't mean any harm. I just am a regular guy going in to vote. The state of Maryland decided that I have a good and substantial reason. I passed a number of background checks, and I just like the ability to go in and vote. And I can't even have it in my car, so I wouldn't be able to take it to work. And that would leave me vulnerable. Thank you so much. I really appreciate the opportunity to speak.
Thank you. Let's take the next speaker, Mark Panek. Mark, are you on?
Yes, Mr. Chairman, thank you. Let me start the video here. And I'm the attorney. I'm the president of Maryland Show Issue. We're an advocacy Second Amendment organization. I live in Montgomery County as well. And I've submitted written testimony on this, which I commend you to. But I wanted to touch upon the constitutional issue here. The bill as written would encompass possession within the home, which the Supreme Court has held a state may not regulate and ban. But this bill would ban it. It would also ban the innocent transport totally concealed or otherwise, in a car or walking along within 100 feet of a polling site. Let me be clear, do not support the open display of firearms at a voting site. But concealed carry permit holders, and I'm one of them, could typically carry completely concealed. No one knows. The off-duty police officer who goes into and conducts and votes at his voting site, he's no threat to anybody. He's not intimidating anyone. People have the right to possess firearms in their homes. They have the right to innocent passage on the way to the range, which this bill would ban because it encompasses public streets. It is overbroad. And what's worse, it actually creates dozens of gun-free zones. Now, there's a misapprehension that gun-free zones means bad guys don't go into gun-free zones, but that's just that. That's wrong. The numbers on that are chilling. Over 90% of mass shootings are done in gun-free zones, as defined by the FBI in terms of mass shootings. People who commit crimes look to gun-free zones. If you would not put a sign in front of your house that says this is a gun-free zone, then it ought not to be in place anywhere where a public assembly is, unless the state is willing to provide armed security. And I hear that the sponsor does not wish to provide armed security. Now, I've been voting in Maryland for 40 years. I've never seen armed security at any voting site that I've ever been to, including Montgomery County. So armed security is not there. And yet the bill would ban the possession by concealed carry permit holders, of which there are only about 26,000 in the whole state of Maryland, and off-duty police officers who are no threat to anybody, on the illusion that they are somehow a threat to people. Well, nobody knows when I carry concealed because it's concealed. Off-duty police officers carry concealed. People like this are no threat to anybody, and they're not intimidating anybody. Now, if the bill were amended to ban open carry at the site, we would have no problem with it because we broke no intimidation factor whatsoever. But it reaches too broadly. It sweeps too broadly. It's overbroad. It reaches into the home, it reaches into the innocent possession of firearms, and it basically penalizes owners who have no intent to intimidate anybody and who are not intimidating anyone. So we think the bill ought to be amended to limit its scope to its purpose. And the purpose is to prevent intimidation. We support it. But that can be accomplished by banning the open carry of firearms within 100 feet, as long as it didn't encompass open carry within the home. And that's a very simple amendment.
Thank you, sir. Appreciate it. That time probably went on for a while now, but thank you for your testimony. Really appreciate it. Any questions of the two speakers? Seeing none, thank you very much for the members. That concludes the public hearing on House Bill 450. We're going to move on to House Bill 481. Is Delegate Barvey here?
I'm here.
Oh, perfect. Delegate Barvey.
Okay. Thank you very much for allowing me to testify again on this bill. And hi, Dahlia. Nice seeing you on the screen there. This is the bill that I introduced last year, which I believe passed the Ways and Means Committee and the House of Delegates. It's a constitutional amendment, and what it would essentially do is provide for the state of Maryland to have the same kind of mechanism for choosing candidates for governor and lieutenant governor as what we have at the federal level, namely when a person wins the Democratic or Republican nomination for president, that candidate then chooses their running mate. And oftentimes they might choose as their running mate somebody that they ran against, which is the case in this instance with President Biden and Vice President Kamala Harris. And so basically this would provide for that. You know, the bill ran out of time last year, which is unfortunate because if it had been put on the ballot this last November, it would have been available for the next gubernatorial election. But as things stand right now, if this passes the House and the Senate, it'll be on the ballot in 2022, and it'll be available for the next gubernatorial election in 26. So Again, I don't have any written testimony. I don't even have that lovely photograph of Rashern Baker and Rich Madalito standing next to one another, who could have run with one another if one or the other had been nominated. But you've seen the bill before, and I hope you can move favorably on it once again. Thank you very much, Mr. Chairman. And of course, I'd be happy to answer any questions that you would have for me.
Thank you, Chair Barbe. Questions, Delegate Hornberger.
Thank you, Mr. Chair. And also to you, Mr. Chair, I have a question on the bill. We actually my office looked into this bill last year because it did get some movement in the House side. The question that I had for you was, would this bill preclude a gubernatorial candidate from running in the primary with a lieutenant governor as part of a political posturing or, competitive advantage and transparency?
Well, I mean, I believe my amendment would prevent that from being done formally, but you could always say, "Hi, I'm Kumar Barve. I'm running for governor, and I'm going to pick
Delegate Hornberger.
Kevin Hornberger,
Yeah,
because
sure.
Hornsberger, because I want to be bipartisan." And actually, that's a bad example because you're not a Democrat. I could say that I'm going to be running with Alonzo Washington because he does such a great job on Ways and Means.
Sure.
So
Eric was hoping you'd pick him.
But then, of course, I could change my mind. So
of course,
take it forward.
Okay. Yeah, just a technical question. Thank you both.
Thank you. And Delegate Barbe, Chairman Barbe, this bill passed the House and the Ways and Means Committee last year, right?
Yes, it did. It ran out of time in the Senate, and the Senate sponsor wasn't able to really take it up for understandable reasons.
Just wanted to let the public know that we're on the right side of this issue. So thank you. Appreciate it. Seeing no other questions on this bill and no testimony on the bill. Thank you, Chair Barbe.
Thank you very much. Have a nice afternoon.
You too. That concludes the public hearing for House Bill 481. Members of committee, we're going to switch to House Bill 536, Acevedo. Is Delegate Acevedo not here with us?
Yes, Mr. Chair, one moment.
Is the time going? Can we start the clock? No, I'm joking. Okay, are you ready, Delegate Acevedo?
Yes, Mr. Chair.
Thank you. You can begin.
All right. Thank you, Mr. Chair, members of the Ways and Means Committee, colleagues. For the record, Delegate Gabriel Acevedo presenting House Bill 536. Colleagues, this is not the first time that this committee or we as a body are having a discussion about public campaign finance and the corrosive influence of unaccountable and dark money in our politics and in our government. And HB 536, in essence, is a step forward. It shifts the balance of power in favor of people by ensuring that all citizens, regardless of wealth, regardless of zip code, socioeconomic status, that they have the greatest influence on their elected officials, as well as the policies that they make. This would encourage greater voter participation in General Assembly elections, because what this bill would do is create a public finance system with matching funds for state legislative races or House of Delegates and State Senate. According to the Maryland Board of Elections website, turnout increased in Montgomery County, both in the primaries in 2014 and 2018. And of course that, some folks attribute that to candidate engagement, but I also want to point out that Montgomery County is a jurisdiction that recently passed a public finance system for our county council elections, and other jurisdictions are also looking at this model from Howard County to Prince George's County to Baltimore City to Baltimore County, as well as other jurisdictions are looking at public finance for a number of positions on the ballot. And what we all know is that regardless of what side of what party you affiliate with, rather, public finance ensures that every candidate has the opportunity to take their message to voters, and that voters have the greatest influence and no other entity or actor. And that's really important in our politics when we talk about things like influence and special interests having greater voices than that of everyday people. And that's what we want to do with this bill. It ensures that state legislative races, there are matching funds, and people are able to have a say in their democracy. I'll also add that it would increase diversity in terms of candidates. What we know is that one of the biggest barriers for women and candidates of color, LGBTQ+ candidates, of course, is campaign finance and being able to finance campaigns because of how expensive our elections are. And so it's time that we reform that, and public campaign finance would do that. I'll point out there are a number of my Democratic colleagues who are familiar with public campaign finance, but for my Republican colleagues, we do have a public finance system right now for our gubernatorial elections. And in fact, one need not look further than the 2014 gubernatorial elections, where now Governor Hogan, then candidate Larry Hogan, used a public finance system in order to take his message, not just to voters, but to run a campaign that took him to the governor's mansion where he is right now. And so we see the benefits of it for both Democrats and Republicans. We see the benefits of it for our democracy. And I'm asking each and every one of you all for a favorable report on House Bill 536, so we can not just change the way that we do things, but ensure that people have a greater voice in their democracy and in their government. So thank you all again, and I ask for a favorable report.
Thank you, Delegate Estevero. Any questions for the delegate? Delegate Hornberger?
Thank you, Madam Chair, and certainly respect what Delegate Estevero is trying to do with the public financing. My question for you is that as we potentially expand that franchise of public financing, obviously the money gets diluted because it's now being spread amongst more candidates. So could you talk a little bit more about what the funding stream would look like for this, and how do we ensure that everyone that does opt in and meet the requirements has adequate access to that capital?
Yeah, so if we look at various models, like for instance, in Montgomery County, it's about dedicating funds to this fund that would be able to do that, and really ensuring that candidates, really all candidates that get into this, we're talking about state legislative race in this case, are able to benefit from this fund is if we as legislators, we as stewards, ensure that that fund has the kind of a money that it should have in it in order for candidates to be able to take advantage of that. So for instance, when Governor Hogan ran in 2014, the fund that he tapped into, there were funds in there and it was well funded. And so not only he, but other candidates as well, Democratic candidates, I'm talking about then Senator Rich Madaleno, was also able to tap into that. And so what we're hoping is not just shifting to publicly funded campaigns, but ensuring that we're putting the dollars that are necessary so that candidates that do choose this option as opposed to traditional funding are able to take advantage of that, not just the funds, but people have an opportunity to sort of have a greater say with small donorships, right? So it's all about whether or not we invest in that.
Okay, thank you, Madam Chair.
Thank you, Delegate Hornberger. Any other questions for Delegate Estevero? All right, thank you. Seeing none.
Thank you, Madam Chair.
Thank you. We'll take Quite a few people testifying. We'll take a few people at a time and then a round of questions. We'll start with Christopher Burnett.
Councilman Burnett's not able to join us. I don't think he's caught up in a city meeting.
Thank you. Next, we have Emily Scar.
There we go. Hi, my name is Emily Scar. I'm the director of Maryland PIRG, the state public interest group, and one of the groups that's been working with the counties to establish this program across the state. We really want to thank the delegate for bringing this bill this year and for holding this hearing before my kids wake up, which could happen at any minute. Get excited. There's no doubt that our democracy is in a fragile state right now, and faith in government has drastically declined as voter participation and civic engagement have as well. Hyperpartisan politics and gerrymandering, as well as the role of corporate influence and large donors, has led to gridlock at the federal level. And small donor public financing of elections is not a silver bullet to solve all of our democracy's problems, but it's a really good start. By creating alternatives to the traditional funding model for elections and encouraging more participation, we can really disrupt the stranglehold that money has on our democracy. And Maryland counties are already leading the nation in doing so. So as you've heard, this bill is modeled after the successes we've seen for local programs in the state, and with some adjustments made to meet the needs of state races. The bill creates a voluntary program that enables candidates to run for office with small donations from their constituents, while remaining competitive with those who still accept large or corporate contributions, which serves the dual purpose of keeping that large and corporate money out of the elections and re-engaging the community in the electoral process. We hope this will also expand opportunities to run for office, so candidates of all backgrounds can run based on the strength of their ideas, not on access to money. As you've seen in my written testimony, Montgomery County had their program run in 2018, and Maryland PIRG did some research on the results, finding that candidates who qualified for the program received nearly twice as many donations from Montgomery County residents of those who didn't use the program. And those who participated had an average contribution of $86 compared to over $1,000 for non-participating candidates. So as more counties move to implement this program, we hope the committee will join them in moving forward a state program as well that's based on these small donor public financing. We'll be back in a half an hour or so to talk about updating the gubernatorial program, so I look forward to that. And we respectfully request a favorable report.
Thank you so much, Ms. Scar. We next have Joanne Antoine from Common Cause.
Thank you. Good afternoon, Chair Kaiser, Vice Chair Washington, members of the committee. For the record, my name is Joanne Antoine, Executive Director of Common Cause Maryland, testifying in support of House Bill 536, which would establish a small dollar public financing program for General Assembly candidates. For the sake of time, since Delegate Acevedo and Emily pretty much highlighted a lot of what I was going to share, I did want to flag that if you look at my testimony, I've provided a chart that shows you, a layout of the match system, how much you would get if you decide to opt into the program and so forth. I did also want to flag, right, and I raised this last year, that the cost of running for office, running for a state senator seat, a delegate seat continues to rise. On average, Senate candidates are bringing in close to $266,000, and delegate candidates are bringing in over $125,000. And, I know for myself, if I were considering a run for office, just listening, hearing those numbers really is intimidating, right? And I know that it's intimidating for, the woman, the person of color, the non-traditional candidate who wants to run for office. Now, the committee at a previous hearing, we had discussions about diversity, wanting to diversify the General Assembly. Delegate Acevedo touched on it as well. And we know that if we were to remove all of these other mechanisms, for getting into the General Assembly, at the end of the day, candidates, have the most issue that they have is really raising money, right? Money that will ensure that they are competitive. And even when these candidates are able to run for office, a lot of times other candidates who have access to larger pools of money really are drowning them out. So, I would say that if this committee, again, wants to prioritize diversity, right? I think the first step that we need to do is create a program that allows for the candidate who doesn't have access to these large, donors, these donor basis for them to be able to opt into a system that allows them to be competitive. Now, I know this might not be the year for it. We're dealing with COVID and so forth. And, you know, you've got a lot of other priorities that need to be addressed, and we understand that. But I do think, you know, there's a political will for it. Marylanders want this. Others who are thinking of running for office are thinking about the amount of money that they need to raise. And I hope that you will, you know, consider moving forward with a favorable report or coming up with a program for establishing this program in the near future. Thank you.
Thank you, Ms. Antoine. And next we will, we'll just take some questions now if there's any for this group. Delegate Hornberger.
Thank you, Madam Chair. I don't have any questions at this time. I apologize.
Oh, all right. May have been up from before. All right. The next person we have signed up is Christy Demnowitz. I'm sorry, I'm on the wrong bill. Give me one.
No, I signed up for this.
Okay, go ahead then.
Hi, well, thank you. Again, my name is Christy Demnowitz. I'm the chair of Represent Maryland. And I've testified a couple of times this year in front of your committee, but just as a refresher, Represent Maryland is an all-volunteer pro-democracy group, and we are 100% grassroots, and that includes myself. And we're in support of this bill. Just, you know, everything that Joanne and Emily have said, we agree with. But I also want to point out that this is something that regular voters who are not, you know, who are politically aware but not necessarily involved with a lot of lobbying are in support of as well, because as both Emily and Joanne have said, there's a lot of faith that's been lost in the political process and in elected officials. And so this is something that can restore faith in our political process and in our government. So we support this bill, and we think that given the recent happenings at the federal level, you know, this is something that the state can do to really signal that the state of Maryland and the lawmakers of Maryland want our government to operate in a very democratic way. So I hope that you will find this bill favorable and move it to the House for a vote. Thank you.
The next person we have signed up is Charlie Cooper. Mr. Cooper, are you there? Yes, I see you. Go ahead.
Okay. Thank you very much. I didn't unmute fast enough. Thank you, Madam Chair and members of the committee for this opportunity to testify on behalf of Get Money Out Maryland. And you have our written testimony. And thank you, Delegate Acevedo, for putting in this excellent bill. So my message is that as expensive as it seems to run for office, and as much of a barrier as it is to everyday Americans, the vicious cycle that's been running for the past few decades that has enriched the already rich means that the elections are very cheap from the point of view of the billionaire class. So already in 2016, the top 1% had 39% of the wealth in the United States. And the bottom 90% had less than a quarter. So 90% of our citizens have less than a quarter of a wealth. You have to get above the 50th percentile in net wealth to get any wealth at all. In other words, that class of people as a whole in the bottom 50% are in debt, net debt. And then since the pandemic hit, the top 666 US billionaires have added more than $1 trillion to their wealth. And the top 100 contributors in the recent federal election each gave between $3 million and $218 million, gave or spent. And that excludes any dark or black hole money that they may have laid out. So one or two of those people could come into Maryland and do a lot of damage. And this bill provides some protection against that for ordinary people who want to contribute to government, who want to say, I am qualified I have merit, but I don't have a lot of money or a lot of wealthy friends to fund me. And this bill gives an incentive for candidates to go out and talk to ordinary voters, get them to give $50, and then it's matched at a very high rate, like 9 to 1 or 6 to 1. And that really, we see that it's working in the counties. So, you know, this bill isn't an absolute protection against the big outside money coming in, but it may provide us with some time to further democratize our system and to give people faith in government, which is eroding very, very fast. And while it does have a fiscal note, it's less than 0.2% of the state's general fund. So we request a favorable report and action this year on this important bill. Thank you.
Thank you, Mr. Cooper. We next have on the bill, we have Christiane Marguerite.
Hi there. I'm actually not Christiane. My name is Jennifer Dwyer, and I'm the Deputy Executive Director at Progressive Maryland. I just don't understand how to use the internet and messed up. I apologize with the confusion. So yeah, I just want to express our strong support for HB 536. I agree with my friends Joanne and Emily. I think this is a great bill because I feel like anybody who has great ideas, a call to public service, and the support of their communities should be able to run for and win a seat in the General Assembly, whether or not they have lots of money or connections to people who do. Winning a race, as you all know, can often require tons and tons and tons of money, and finances really should not be a barrier to Marylanders being able to elect the folks who they feel will be the best at representing them. So by making it more feasible for a candidate to raise the money they need for their race in a purely grassroots fashion, the pool of candidates will diversify and become more reflective of everyone who lives in our state, which is critical for ensuring that no voices are being left out of our government and that the needs of every community are being met. In addition to creating a more reflective democracy, public financing also helps candidates out by allowing them to spend more time with the people they hope to represent and less time worrying about fundraising. I don't know very many people who love fundraising. It's time consuming. It's not easy. So public financing creates an option for candidates who choose to be able to raise all the money they need while knocking on doors and talking with voters. As a few folks noted earlier, in 2018, Montgomery County passed their public financing program for county executive and county council seats, and a large percentage of candidates opted into the program, including incumbents who had previously been fundraising in the traditional way. Howard, Prince George's, Baltimore City, and most recently Baltimore County, with the support of 57% of voters at the ballot, have all passed programs for their city and county governments. So public financing is something that's popular with voters in different parts of the state, rural, urban, suburban areas. Over half of Marylanders now have the opportunity to participate in public financing at the local level, and we should expand that to the General Assembly too. So thanks so much for the opportunity to testify, and we urge a favorable report.
Thank you very much. Reverend Kobe Little? I don't think
I have to jump in. Yeah.
Okay. Thank you. Questions for these last few people who spoke? Any colleagues? All right. Seeing no hands, thank you. We are done with the hearing on House Bill 536. To members, we have 5 more bills left, all from members from our committee, starting with Delegate Feldmark, House Bill 423.
Thank you, Madam Chair, and thank you, committee members. House Bill 423. You will recall this bill from the past couple of years, although I was not the delegate presenting it to you in years past. This is about ensuring accessibility for voters with disabilities and making sure that voters who rely on using our ballot marking devices have the same right to a secret ballot that the rest of us enjoy when we go to cast our votes. Again, you know, this is a bill that you've heard a few times, so I will not belabor the point, but I think we can all agree that privacy in voting is fundamental to our democracy, and Maryland needs to provide equal access to the ballot so that voters with disabilities enjoy the same secret ballot that voters who mark their own ballots enjoy. Currently, the ballot marking devices we use, as you'll recall, produce a dramatically different ballot than the paper ballots that voters fill out themselves without a device. And that leads to, of course, the ability to easily distinguish those ballots from the others. So I'm going to keep my testimony on this very brief. It's a fundamental point of ensuring equal access to voting rights, and I'm happy to answer any questions.
Thank you, Delegate Feldmark. Any questions for Delegate Feldmark? We do have about 8 people signed up to testify. Seeing no questions, thank you, Delegate Feldmark. We'll come back to your other bill in a bit. Next, we'll take Cheryl Gottlieb. Is Ms. Gottlieb here?
Hi. Yes, I'm here. It took me a minute to mute. Hi, my name is Cheryl Gottlieb, and I am a resident of Towson 42A, and I have cerebral palsy, and part of that is a visual processing difficulties. So I can't fill out paper ballots, not because of any motor issues, but because I can't actually see correctly what it is that I'm reading. I've had significant difficulty every time I've gone to vote. I have an obvious disability. I use a power wheelchair in public a lot. Never once have I ever been asked by any election official when I come to vote whether or not I need the ballot marking device. And when I request it, never once has it ever been turned on and functional. One time I went to the Towson University early voting site, and they were kind of both, they had 2 of them. They were crammed in a corner, and one of them was up on top of a cabinet with handles sticking out in the way and no way to pull under in a wheelchair. And when I asked about that, they said that room didn't have enough space for the amount of people that they were supposed to be setting up for. So they just left out the second ballot marking device. Of course, I was furious and said that if they couldn't, it didn't have enough space, you get rid of one of the regular tables, not the accessible ones. My mother is a resident of Montgomery County. She doesn't have any sort of disabilities that impact her voting ability. But as I understand the current law, every voter that goes to vote is supposed to be presented with the option of using a ballot marking device. And she was not. I went with her to early voting. And so I asked her, how it went, and was she asked this question, and she was not. And nor are several, senior citizens that I know that have motor planning issues and vision issues and could use the ability that the ballot marking device has to have larger print. Nobody knows they exist. The judges don't know how to use them. And it would just be so much of a less stressful process if every single person voted the same way. We wouldn't be having these kinds of issues. So that's all I have. Thank you.
All right, thank you, Ms. Gottlieb. We next have Christy Demnowitz.
Hello, thank you again. My name again is Christy Demnowitz, Chair of Represent Maryland. And I'm actually, for this bill, we're actually very favorable of the concept of this bill, and listening to Cheryl's story really reinforces how important it is to fix this problem, because voting should be accessible and equitable to every eligible voter in Maryland. But as I mentioned, we are favorable with amendments on this bill with just one concern, which is that we do have a law in place that we have paper ballots, and we have them for a reason. It increases election integrity, and it prevents any kind of shenanigans from happening with the ballots themselves. So when we were doing research on what a ballot marking device is, because I don't have any understanding of what they are. So via Google research, I learned that there's 2 different types of devices. One can still use a type of paper ballot and the other one doesn't. So we would just request that the solution that is decided for this bill still includes paper ballots, so we don't go a step back in what we had used previously, which was I don't remember what it was before, but it wasn't paper ballots, and I remember there were problems with it. So we just request that this bill includes a commitment to paper ballots with a process that's equitable and accessible to all. And that's all. Thank you all.
All right, thank you very much. Next signed up is Jonathan Lazar.
Good afternoon, Madam Chair and distinguished members of the committee. I'm Jonathan Lazar. I'm a professor in the College of Information Studies at the University of Maryland, and I'm the incoming director of the Trace Research and Development Center, the nation's oldest research center on technology and disability. I'm here today representing my own opinion and not that of the University of Maryland. I'm here to state my support for the bill, and there's a reason why, right? The reason is that Maryland has this problem of ballot segregation that other jurisdictions and states around the country do not. No one yet has already kind of held up their ballots. Just to give you a sense, right? We've got a very thick ballot, right? And then a very thin ballot, the fat ballot and the skinny ballot, right? The ballot marking devices actually create skinny ballots, which are, it's very easy to tell the difference between a skinny ballot out of a ballot marking device and a standard paper ballot. Now, you might say, well, we need both paper ballots or we need ballot marking devices, or, you know, the reality is only Maryland has this problem with ballot segregation. In 2018, I actually did a research study where I investigated all of the other jurisdictions and states in the country that use the same ballot marking devices used in Maryland, the express vote ballot marking device. It's published in the Election Law Journal, and you actually have information about it in my written testimony, which I submitted. Maryland is the only one that is having this problem. Why? Because all of the other states and jurisdictions that use the skinny ballot, that use the ballot marking device ballot, right? They either require everyone to use the ballot marking device, they encourage people to use the ballot marking device, or when you walk into a polling place, you're told, would you like to use the paper ballot or would you like to use the electronic ballot, the ballot marking device? So this idea, right, of the problem that happens in Maryland, where you have, you know, a number of precincts where you have only one person using the skinny ballot, and suddenly that person has lost their ballot secrecy, or even one or two or three ballots. If you only have 3 ballots in one precinct using the ballot marking device, you know that those were voters with disabilities. Why? This is solvable. This is completely solvable. Maryland had this problem in 2016. Maryland had this problem in 2018. My data collection related to 2018, but I've analyzed some recent data from the State Board of Election. And in the 2020 general election, the problem actually got worse. There were more polling places that had only one ballot, right, voted on using the skinny ballot. There were more than there were in 2018 in the general election. So this is an ongoing problem and it's getting worse, but it's fixable, and Maryland is the place where we have this problem, but it's solvable. We know how to do this. And I believe that House Bill 423 actually does solve this problem, and that's why I'm in favor of the bill. Thank you, and I'm happy to take any questions.
Thank you, Mr. Lazar. We're going to take one more person and then some questions and then a few more people. Ronza Othman, thanks for joining us again.
Good afternoon. I hope my Zoom is working.
It sure is.
Okay, great. My name is Ronza Othman, and just for informational purposes, Sharon Manecki, who's later on this panel, is also using the same account I am. So please don't mute me, whoever the administrator is, when we're done. I am the president of the National Federation of the Blind of Maryland. I am also obviously a voter, and I've experienced this challenge that Jonathan and others have described firsthand as recently as 2020. I am very obviously blind, and when I walked into a polling location, I was not given the option of a ballot marking device. I had to ask for it, despite supposed new policies that the Board of Elections claimed to adopt. I had to ask for the accessible ballot, and then I was taken to the ballot marking device that was not set up. I had to help them set it up. And then, of course, my ballot was identifiable. When I walk into my local voting location, they know me by name. I'm one of the people in the neighborhood who is blind. And so people are going to be able to identify my ballot and identify how I voted. The bottom line is our constituents, our members, including myself, and those who otherwise have print disabilities, we have segregated voting in Maryland for us. We have to get in a line that is different from the line that everybody else gets in to vote. And then our ballots are identifiable. So we do not have secrecy or privacy in terms of our selections. The young lady earlier who talked about there being a requirement of a paper ballot, we are not talking about eliminating a paper ballot. We are talking about the method by which we mark the ballot, because Maryland state law already has a requirement that says there must be paper ballots generated and produced for purposes of audits and everything else. And so we're just talking about the method by which we mark the ballot. And we recommend, and frankly, it's now been 3 years and 3 elections that we have had this experience where we are segregated sheerly because of disability. This is a civil rights issue. We are pleading with you to do something this year because the Board of Elections has not, and nothing will happen if the General Assembly does not take proactive action to ensure our ballots are secret and also to ensure that we're not segregated because of our disabilities. I'm happy to answer any questions, and thank you to the chairperson and vice chairperson and the entire committee for your attention and hopefully your support.
Thank you. And thank you, Ms. Hoffman. And we're not taking Ms. Manecki immediately after you, so we will mute for a few minutes. But first, we're just going to take questions of the first 4 people who testified. If there's any questions from members. All right, seeing none, we'll just keep running through. The next person that signed up to testify is Joel Zimba.
Good afternoon. Thank you for having me. I am in favor of 423. In 2020, I voted at my polling place, Margaret Brent Elementary School in Baltimore City, and that was for the special election for District 7. And my story is somewhat similar, except that when I went to vote, the ballot marking device that I used because I'm blind did not function. It didn't give audio feedback, which is what I used to manipulate the machine and cast my vote. And the poll workers were stumped. Keep in mind that this was at 4:15 in the afternoon. The polling place had been open for some 9 hours or so, meaning that at that point, not very many, if any, people had used the ballot marking device. And they could not get the audio output to function, and the process ground to a halt. Ultimately, they had to call the tech support hotline, and that took a good 30 minutes. So bearing in mind that there was one question on the special election ballot, and that was for replacing the late Elijah Cummings, voting would normally have taken something on the order of a minute, maybe 90 seconds at the most. And for me, it took considerably longer, something like 45 minutes altogether, because you had to select in a fashion that was not accessible to me. You had to select on the screen somehow the party affiliation in order to then vote. And then that made the machine speak the ballot output. And once that was done, we moved forward, and that was a simple process. And the training of the poll workers should have included that. But it means that because of the lack of use of the device and the preparation of the poll workers, my voting experience almost became a non-voting experience. Not everyone has the luxury of spending that much time in their polling place. Fortunately, I was able to do so. And this is an ongoing problem. It's not the first of my voting stories. Of course, so few ballots being used by the ballot marking device throughout the day does mean that my ballot very well may not have been secret, which we've heard about before. So I would love to see this process changed and improved, and I hope to see you all in favor of the bill. Thank you.
Thank you so much, Mr. Zimba. We next have Ed Jackson. Mr. Jackson here. Not seeing him immediately. Next, we have Sharon Manecki.
Thank you, Madam Chairman, members of the committee. First, want to thank Delegate Feldmark for bringing the bill forward for us again this year. And I want to make a couple of comments on the fiscal note. So this fiscal note is kind of a regurgitation. They put up the same stuff every year. For example, they talk about having to buy tables to put the ballot marking device on the table, but you also have to put the hand-marked ballot on the table. So, you know, I think this is a trumped up thing, this fiscal note. But what I would suggest to you is that what we're looking for in this bill is the political will to solve the problem. Now, these machines, these current ballot marking devices that we use are leased by the state of Maryland. So you're not obligated to use these particular machines. You could look around, and I would hope that the committee would tell the Board of Elections to look around and get cheaper stuff, because it does exist. So the question comes down to, are you really going to solve this problem, or are we going to have more of the same? And while this isn't a nice thing to say, we feel that if it was any other protected class having this problem, that it would be solved. So thank you for the opportunity to share my thoughts with you.
All right, thank you. Thank you, Ms. Manecki. The next person, I think the last person we have signed up is Luann Blake.
Yes, thank you, Madam Chair, and good afternoon to the members of the Ways and Means Committee. I'm not going to repeat what other folks have said before me, but what I do want to talk about are the advantages of having all voters use ballot marking devices. When you have everyone using BMDs, you don't have the stray marks that you have with hand-marked ballots. So, you know, someone crossing out a candidate when they realize that they filled in the wrong bubble, or just, you know, putting a stray mark on the hand-marked ballot. That's not an issue with BMD. So you don't have the tabulators rejecting ballots because BMD ballots, because they have no stray marks. Another advantage of using BMDs is that you can't overvote a contest with a BMD. It will tell you that you're trying to overvote and that you need to deselect a candidate. Again, you know, you won't have issues with the tabulator rejecting a ballot because of an overvoted contest. Also, a voter can change their mind before they print the ballot when they're using a BMD. So if they realize that when they're reviewing the ballot that they mistakenly voted for the wrong candidate, they can change that that vote and then print the ballot out. So there's a number of advantages to using ballot marking devices. Also, BMDs are not connected to the internet. As far as I know, I have not heard of a documented case of a BMD being hacked in an election setting. You know, as long as the elections office is using best practices, that should not be a huge security risk. And as Sharon mentioned, there are some cheaper alternatives out there now. There are 2 different systems, ballot marking devices that use off-the-shelf tablets and printers, and they are significantly less expensive than the BMD that we're currently using. So there are a lot of advantages, not just to voters with disabilities, but to all voters in using ballot marking devices. You know, poll workers will more likely be well trained. The machines will be set up and running when a blind voter shows up at the polling place. So there's all kinds of advantages. And so therefore I would urge you to favorably report on this bill. Thank you.
Thank you so much. Any questions on from the, any questions? All right, next we have Kevin Canali from Mako.
Good afternoon, Madam Chair, members of the committee. Kevin Canali here in opposition to House Bill 423. I want to make very clear right off the bat that Mako does not raise policy objections with the goals outlined in this legislation, which is to ensure that voters with disabilities are provided the same access to voting that is provided to folks without disabilities. Our concerns are merely practical and cost-driven. I also want to make it very clear that we think this needs to be fixed. There's no doubt this is a problem, but we don't have the ability as counties to fix the problem. We are reliant on the State Board of Elections to make a decision here as to how they want to move forward. On that note, there is pending litigation between the National Federation of the Blind and the State Board of Elections. That litigation has not been resolved. It is still pending, and we think that this bill may be premature before that litigation is settled. And, as according to the bill's fiscal note, and I understand there may be some concerns about the fiscal note, but according to the fiscal note, counties would be responsible for $4.8 million to $5.4 million per year to fund some 18,000 ballot marking devices, to our share of the lease of those devices, to accommodate eligible voters, as well as costs for increased storage and transportation. We've also been told by our local boards that there will be substantial costs for information technology personnel to test, prepare, troubleshoot, and maintain these additional ballot marking devices. So under state law, we have no choice but to fund these costs, which compete against limited local funds for schools, public health, public safety, roadway maintenance, and other essential public services. Again, we believe with litigation pending, this bill is premature. It would place a costly mandate onto county governments to carry out a new state policy. We do think this is a problem. We want to see it fixed, but this is a bill that's premature and it has a massive fiscal note for counties, and we'd ask for an unfavorable report on House Bill 423.
All right, thank you, Mr. Canali. Any questions? All right, thank you. Seeing no more questions, we're done with the hearing on House Bill 423. We now have House Bill 424. Delegate Feldmark.
Thank you, Madam Chair, and hello again to everyone. House Bill 424 is the Maryland Fair Elections Act. We've already had quite a bit of conversation and testimony today about public campaign financing. And, I think the same principles are really what's motivating this legislation to limit the disproportionate impact that large donors have on our political process and on public policy, to give everyone a voice, to promote participation and confidence in our democratic process, and to expand access to potential candidates to run for office. This bill is very similar to a bill that I presented to you last year. The key difference is that it is scaled back to focus solely on gubernatorial races. Last year's bill included other statewide offices as well. But we really, I think it's important to focus on improving the existing program that we have for public campaign financing in the governor's race. And this would improve on our existing program in a few key ways. One, it would shift to a tiered matching program to really focus on giving the greatest match to small donations. It provides for the Fair Campaign Financing Fund to be adequately funded. Public campaign financing doesn't do us any good if there's no funding to finance a campaign. And finally, it authorizes civil penalties for the program. So again, I know you're already familiar with the basics. I will end there, asking for your favorable report and happy to answer any questions.
Thank you, Delegate Feldmark. Any questions for Delegate Feldmark? All right, thank you very much. We do have quite a few people testifying on this one. I believe I was already told earlier that Christopher Burnett was not here. And so we'll next take Emily Scar from Marysburg.
Hello again. For the record, my name is Emily Scar. I'm the Director of Maryland PIRG in support of HB 424. Thank you, Chair and Delegate Feldmark, for this bill. Again, we already have a public financing for gubernatorial candidates, so this bill just updates and improves on that program to reflect what the counties have been doing, which is a common step forward for the state on furthering campaign finance reform. And this year really is the year to do it, to ensure the program is working for the 22 election. As you'll see in my written testimony, we've also done some research on gubernatorial campaign financing and found that disproportionately money for our gubernatorial races is coming from out of state and corporate donors, and not reflective of Marylanders. So the report found that actually that more than 80% of the money raised for the last 3 elections for governor came from contributions over $250. Sorry, there's my toddler. Despite representing just of all the donations made. So it's really due for an update. Our last program was implemented in the 70s. It doesn't take into account the unprecedented onslaught of large money that we've seen into our elections in the recent years. And the existing program also allows candidates who are using it to still accept large and corporate donors. So this new program really is more reflective of where we want our public financing to be going. The version of this bill actually did pass through 2 committees in the Senate last year before we had to shut down from COVID. So I think there is a lot of interest in moving it, and I hope your committee will do the same. And then, as the delegate said, we obviously need to fund this. And I think this has been addressed before. We estimate the cost to be $4 million a year to have a really full program with lots of candidates, which is a really worthwhile investment in our democracy, and to ensure that our races for governor are reflective of the community and enabling candidates to run for office without having to have those really big ties to big money. So I'll leave it to that and hope you heard me without my kids screaming and Moana in the background. We recommend a favorable report.
Thank you so much, Ms. Scar. I think we could all hear you very well. We next have Jared Demarinis from the State Board of Elections.
Well, thank you, Madam Chair. I just wanted to say the State Board supports the provisions on increasing the enforcement authority for the enumerated offenses under Title 15 of the election law article here. I'll keep my testimony brief, just to that, these are technical violations that are best suited for the State Board of Elections to issue civil citations, very similar to the same penalties that we issue to you, the non-publicly financed candidates under Title 13. So it's just a natural extension of our current functions. We've had 2 gubernatorial elections, and there has actually been inquiries for this one upcoming into the program. So that is important for the State Board to make sure that we have that enforcement authority. And I'll just be around to answer any questions later on as well.
Thank you so much, Mr. Demarinis. And then Joanne Antoine.
Yes, for the record, Joanne, Executive Director of Common Cause Maryland, testifying in support of House Bill 424. Panelists before me have really covered, all of the pieces, that I plan on covering as well. I will say, that when we look at the programs that have been established in jurisdictions like Montgomery County, Baltimore City, and soon Baltimore County, while they're crafted, depending on that jurisdiction, they are all structured the same, right? These tiered match systems where small dollars are matched at the highest rate. And I think administratively, it just makes sense, right, to change the structure of the existing program. I think it causes less confusion to constituents who want to, make donations to these candidates and want to understand how the matches work. And I think for candidates as well, it just causes easier processing or easier ways to understand it. And I'd even say for the State Board, right, where Jared is tasked with, working with candidates who are navigating these programs, being able to provide them with similar structures just makes the most sense. And obviously making sure that there is some funding available in the program as we prepare for 2022. My hope is that we will see more people of color, more women, running for office. Maybe our next governor is a woman as well. And, she should be able to, if she chooses to opt into a program like this that is well-funded, where small donations that come from people who look like me, are amplified at the highest rate. So I hope that, the General Assembly will listen to the public here. The public wants these programs. They love them. They feel like their voices are being drowned out. And I think this is a small administrative fix, just keeping in mind that we are not creating anything new. We are not asking you to fund something new. All we're doing is changing the way that it works and putting some money as we prepare for 2022. So I urge a favorable report. Thank you.
Thank you, Ms. Antoine. From the first three people who spoke, Ms. Scar, Mr. Demarinis, and Ms. Antoine, are there any questions? And then we have a few others signed up. Seeing none, let me continue on the list. We have Christy Demnowitz.
Hello again, and good afternoon. Thank you, Chair Kaiser, Vice Chair Washington, and members of the committee, and thank you to Delegate Feldmark for introducing this bill. Again, I'm Christy Demnowitz with Represent Maryland, and we're a grassroots pro-democracy group, 100% volunteer, and we have members all across the state. And we're in support of this bill and every other public financing bill that is in front of your committee, because this is what voters want, and voters are tired of big money influencing their elections. So anything we can do to mitigate that is important. Again, as I mentioned on the last bill, there's a lot that's been happening at the federal level that is making people more aware of problems within government. And this is a solution that the General Assembly can take in order to show that it's serious about proactively addressing those issues before they get closer to home. So we would ask that everyone supports this bill. Anything we can do to strengthen government, anything we can do to strengthen voters' opinion of government is important. And as others have mentioned, the cost for this is very, it is insignificant. It's not a lot compared to our state budget. So I think it's important to keep in mind that it doesn't cost a lot of money, but even if it did, it would be well worth it, because there's nothing more priceless than democracy. And so with that, I will finish up and ask you to find this bill favorable. Thank you.
All right, thank you, Ms. Demnowitz. Next, we have a former colleague. Welcome back, former Delegate Heather Mazier.
Thank you, Madam Chair Kaiser, Vice Chair Washington, and it was delightful to see your Chief of Staff, AJ Lineman, on the Zoom there for a second. I am here at the request of Common Cause to offer a few remarks and answer any questions you might have as someone who participated in the gubernatorial public campaign finance system back in 2014. I have to give a deep shout out of gratitude to Jared Demarinis, who partnered with us to really navigate what was a new tapping into a fund that had sat and grown rather dusty over 20 years of collecting funds, but no one participating in it. And I think through the participation, we gleaned a lot of information about how this worked well in some ways and could be improved in other ways. I want to thank Delegate Feldmark for bringing this legislation forward and all the organizations who are behind it. My comments are in favor of the bill and might possibly with some slight amendments from my own experience. I would say that for the fund to be effective, the caps, I think, maybe need to be lifted a little bit on overall amount of money that can be raised. We live in a large state with two very expensive media markets, and the limits on the total amount that you can raise in the primary was just too low to be able to effectively get your message out. I also, on my own, chose not to take corporate money, even though the existing system allowed it. And one thought I always had in the back of my mind was, what if, is there a way to allow for corporate giving to fund the program, but not through the individual candidates? So it's no longer influencing any individual candidate, but it could be a source of funding for the overall matching money that's in the fund. If the General Assembly is struggling with finding ways to invest in the fund, that might be an alternative idea to at least explore. On the new tiered matching, I think it's a really great idea. It gives a lot of emphasis on the early lower donors, but I do have a little concern that it sort of caps out, like that last $100 up to your $150 isn't matched. And I know that when we were working it, we got a full $250 for every $250 raised. And even under that circumstance, it was a little restrictive in having enough resources to be able to compete and get a message across in a state as large as ours. So overall, the takeaway was the program was amazing. I'm so glad it existed. I want it to continue in perpetuity for other candidates who are looking for getting big money out of politics. And I think with all of your brilliant minds around the table can come up with some adjustments to the program to make it work better for future candidates. I'd be happy to answer any questions.
All right, thank you. We have one more person signed up, Reverend Kobe Little.
Good afternoon, Madam Chair. Thank you. Good to see the Vice Chair of this committee and all the members of this committee. I'm glad that technology affords us the opportunity to gather this way. Want to thank Jessica Feldmark, Delegate Feldmark, for leading with this legislation again. I'm Kobe Little. I represent the Maryland State Conference of the NAACP, and we want to go on record in support of House Bill 424, as well as House Bill 536. My colleagues have spoken clearly about how this legislation will strengthen our democracy, how it will reduce the influence of big money, how it will create the opportunity for those who might not be able to be competitive in fundraising to actually participate in the electoral process. I'd like to take the time that is remaining to remind us just how fragile our democracy is, and to encourage us to seize this opportunity to do everything that we can to strengthen our democracy. This country, and by extension, all of us in Maryland, have seen what happens when unbridled money takes to the executive branch. We've seen what happens when we are not vigilant in protecting our democracy. We got a crash course on that on January 6th. Hopefully we're not facing those kinds of issues here in Maryland specifically, but there's a lot that we can do to strengthen our democracy. And I'd ask the members of this committee to vote favorably on this legislation as a means of standing up and being heard that democracy matters and that we must protect our democracy. Thank you, Madam Chair.
Thank you, Reverend Little. Any questions for the last three, Christy Demnowitz, our former colleague, or for Reverend Little? All right, thank you all. Seeing no further questions, we're done with the hearing on House Bill 424. To members, we have 3 bills left. We're going to take them in a different order and take Delegate Guyton's bill last. Delegate Hornberger, House Bill 544.
Okay, thank you, Madam Chair. And for the record, Delegate Kevin Hornberger with House Bill 544. And this bill seeks to repeal the popular vote pact that we entered in 2007. Now, you may be asking, why do we need this bill? The reason that I bring this bill before the committee today is to avoid what I feel is a looming constitutional crisis. Now, a little bit of preface on that constitutional crisis. If you followed in the news, and if you remember back to our hearings earlier this week, we heard HB 202 from Delegate Dana Stein. That bill actually sought to remedy an issue that was adjudicated by the Supreme Court back in July 6, 2020. The case basically had a state that had a presidential elector that decided that they no longer wanted to vote for the person that they had pledged to vote for in the presidential election. The state appealed to the Supreme Court, and the Supreme Court basically punted it back and said, not only was the state able to punish that elector and replace them, but we at the federal level feel that this is a states' rights issue, and it's up to each state to determine how they will pick or how they will punish a elector if they decide to flip and vote for another presidential candidate. Now, how does this equate to a constitutional crisis? Well, in 2007, when we opted into the national popular vote, we basically said that as Maryland, regardless of the way the election turns out, if this is ratified by a certain number of states, a plurality above 270, then we will become a voter for that popular vote candidate. So in 1980 and in 2004, a Republican not only won the national popular vote, but they did not win the state of Maryland. So if that were occurred again in the future, and we pass a Delegate Stein's bill, which most likely we will, then we would have a group of presidential electors that would be voting for the person that won the popular vote, which could be someone different than who Maryland voted for. The only way to remedy that would be to eliminate that entire board of electors and eliminate that entire board of secondary electors, and then replace them with someone who violates what we decided on earlier in 2007. So you might ask the question, well, can all of these things happen? And my answer to you is yes, they have happened. Again, 1980 and 2004. So until we repeal the requirement to become part of that national popular vote, we are in essence setting ourselves up for what I think would be a very thorny legal battle on our ability to replace electors. And with that, I'd like to take any questions. Thank you, Madam Chair.
Thank you, Delegate Hornberger. Any questions for Delegate Hornberger? Not seeing any questions, Delegate Hornberger. I know you wanted them.
I sure did, Madam Chair.
There's still a chance. Ann White is here to testify in favor.
Yes, please. Hello. Good afternoon, Chairman Kaiser, Vice Chairman Washington, and distinguished members of the Ways and Means Committee. Thank you for this opportunity to speak in favor of House Bill 544 to repeal the state of Maryland's consent to participate in its previous agreement to elect the President of the United States by national popular vote. And thank you, Delegate Hornberger, for bringing this important bill to the committee. My name is Ann White, and I'm a citizen of Anne Arundel County. Currently, our 10 electoral votes go to the winner of the state and give our state a voice in the selection of the country's leadership. Back in April 2007, Maryland's legislature was the first state to sign on to this misguided project. Who knows what their thinking was at that time? I'd like to make 3 points. First, the United States was founded as a federation of states with balanced representation from each state to govern based on population. As such, the eventual winner needs to build a coalition of supporters from all the states, not just the most populous ones. Failure to build such widespread support throughout the states would mean that a few large states would make selections for everyone, thus disenfranchising all of the voters in smaller states like Maryland. Failure to build such widespread support throughout the states would mean, the 50 states have vastly different economic, social, and cultural interests. What is good for the coastal states would certainly be different than the heartland states, just as the northern states would be different than the southern ones. A national election by national popular vote would allow only powerful regional interests to win a presidency and govern the whole state as they see fit, regardless of regional differences. Rural and small town citizens would have no voice at all. Let's not forget who supplies the nation's food. Secondly, our Constitution clearly states that any interstate compact requires congressional consent. At its inception, the founder of the National Popular Vote Project, John Zoza, knew that such a compact was unconstitutional, and proponents of this effort are simply trying to sidestep the congressional process in a rather sneaky way. Our Constitution created the Electoral College to provide a balanced geographic system and protect states with diverse interests within the governing bodies. Third, in the last 116 years, the Electoral College has elected an exactly equal number of Republicans and Democrats to this nation's highest office of 15 each, thus refuting the erroneous claim that the Electoral College is biased, and further shows that the current method is stable and encourages the candidates build support among all voters in order to win. My written testimony includes a chart showing just who those, the 15 each ones.
In conclusion, not only is the national popular vote unconstitutional, it is dangerous for the future of this country, and Maryland needs to rescind its participation in this dangerous trend. That said, I strongly encourage a favorable vote on House Bill 544 to repeal Maryland's participation in the national popular vote. Thank you.
All right, are there any questions? I do want to, excuse me, point out to members, hearing from our analyst that the National Popular Vote Compact is not unconstitutional, nor does it need Congress's say so to approve it. I just want to clarify that from our analyst. Delegate Wilkins with a question.
Constitution.
Thank you so much for raising this issue and your thoughtful presentation, Delegate Hornberger. My question is, so this has been in place for several years now. Do you have a sense, I'm not sure if you share this, around how close the agreement is to being enacted, and if there are other states that have or are moving towards repealing it?
Yes, great question. And last checked, I think we're 2 states away from enacting the compact. So it's imminent.
Wow, okay, thank you.
Yep.
Thank you, Delegate Wilkins. Delegate Hornberger, any other questions? All right, we have one more person signed up to testify. Oh, no, I'm sorry, we do not. It was just, the rest is written testimony. Seeing no more hands on House Bill 544, Delegate Hornberger, House Bill 576.
Thank you, Madam Chair. For the record, again, Delegate Kevin Hornberger here on behalf of HB 576, political clubs and donations. I want to start off by saying what this bill seeks to do and what this bill does not seek to do. This bill seeks to grapple with a concept that we'll hear many times in this committee, and that is dark money in our races. However, this bill does not seek to shutter clubs or put any onerous reporting requirements on said clubs, be they Republican, Democrat, Libertarian, Green, etc. And I also like to preface this bill with saying that we are open to amendments, and we have gotten some feedback on the clubs in terms of that work. So with that said, I want to go in a plausible scenario that it can happen with a club. And then we can also have any questions answered by the Board of Elections. So currently, if you are a candidate, you can receive funds from a political club. If you look at the drop down in your treasurer report, there is an option for donations received from a political club. Now you may ask, okay, well, what is the limits on that? It's just like any other entity. It is a cap of $6,000. Now, if you were to do research and look at candidates that have received monies from clubs, you would see in there, for example, Prince George's County or Montgomery County, Democrat or Republican club. If you then in turn went back to the club's financial report, you would find that clubs are not required to submit financial disclosures or campaign finance reports. So the question becomes, if I was a bad actor or a nefarious person, currently, it is legal for me to give as much as $6,000, whether that be cash, whether that be check, etc., to a club. That club could then take that money, in essence, laundry it, and then give it to a candidate without any chain of custody or records, and it would appear on said candidate's club, the receiver of those funds, as coming from the club. Again, this is perfectly legal. It has happened. It happened as recent as our last election cycle. And in my opinion, after serving for many years on this committee and actually being on the voting subcommittee, this is one of the last major loopholes for dark money in races. And, this bill seeks to close that. I also am entertaining the idea that a club would only have to participate in this recordation if they made donations to other campaign entities. That is on the table as well. We don't want to discourage the mom and pop 5-10 member club that's only accepting dues, not really playing in any races, put any burdens on them that might jeopardize their membership or get them in trouble with the state board. So again, the concept of this bill is to close out that dark money loophole. And with that, I'd like to take any questions. Thank you, Madam Chair. And you're on mute.
Thank you, Delegate Hornberger. Any questions for Delegate Hornberger? I'll ask a quick one, and I do think you referenced it. Maybe like a threshold of $1,000 like we have now for the affidavits, because most clubs
Yes.
don't have it all.
Correct.
So, okay. All right.
Yeah,
thank-
we're very open to amendments, and thank you for taking the time to hear the bill.
Of course. All right, thank you. We do have two people signed up to testify. The first is Christy Demnowitz.
Hello again, everyone. Thank you. Again, my name is Christy Demnowitz, Chair of Represent Maryland. And we are a grassroots organization, and we are a volunteer organization, and we have members across the state. But we actually made the decision in 2017 to register as a PAC so that we could fundraise. And, you know, that's really to pay for our administrative things like our website and printing and things of that nature. So we do support this bill because we are against any opportunity for dark money to influence politics. However, we believe that there needs to be a very clear, defined definition of what a political club is in the bill. We weren't able to find it in any other, you know, laws to refer to. So our concern is that if this bill is enacted without a clearly defined definition, it could hurt grassroots organizations who are not, you know, aren't necessarily fundraising, but they might still, some people might still think they have to do reports and, you know, could get them in trouble. The campaign finance system in the state is not exactly clear, and it's not super user friendly. So we don't want it. We don't want this law to create more of a problem for people who are just, you know, activists. So again, if this bill is amended to have a very clear definition of a club and maybe the threshold, like you mentioned, we would support it completely. But we do think it's a good idea to close loopholes that allow for dark money. Thank you.
Thank you so much. And Mr. Cooper?
Thank you very much, Madam Chair and members of the committee. And Delegate Hornberger, thank you very much for bringing this. This is something that I had discussed with Jared Demarinis over the years, that I also cannot find a definition of political club in the existing statutes, which creates an opportunity for money to come in from pretty much anywhere. And then it could be funneled to anywhere, and the voters would not know where it's coming from. So we are offering amendments to avoid putting onerous requirements on small clubs that do traditional activities. We were offering a definition of a political club. I'm sure with the brains on the committee, you can improve on what we've done, but we want to just give you a place to start. And then we're saying, as to filing all these reports, that the criteria should include how big the annual dues are, the largest contribution, single contribution that was received, the largest single expenditure that was made, whether it was a contribution to some other group or an independent expenditure, and the aggregate expenditures. So with those four criteria, I think you could separate the small clubs of activists, local activists, from money funneling machines. But I think this is very necessary. When I testified on the other bill, I testified about how much money is out there from super wealthy people who just, you know, they have billions of dollars, and an operation like this would be absolutely nothing to them. They could hire someone to do it for them, and use this loophole to really swing an election at any level in Maryland, especially since there's no definition of what a political club is. So please seriously consider the amendments and do move this forward. Thank you very much to Delegate Hornberger and the committee.
Thank you, Mr. Cooper. Appreciate it. To members, any questions from either of these two witnesses? Or Delegate Hornberger, who was dying for a question? All right. Thank you to the First Lady of Cecil County. Thank you to everyone else testifying. We're done with the hearing on House Bill 576. He is blushing, but that's his self-proclaimed title. Delegate Guyton, House Bill 493.
Thank you, Madam Chair, members of the Ways and Means Committee. I appreciate it. I am, for the record, Delegate Michelle Guyton from District 42B, and I'm here today to present to you and to thank you for your consideration of House Bill 493. Voting locations, accessibility by public transportation, and voters with disabilities. So this bill, and if you have your bingo card, get ready because it's a simple bill. It doesn't cost anything, and it's very common sense. So there are your bingo cards for today, your bingo slots for today. It requires that in areas with fixed route public transportation systems, the boards of elections give priority to polling places, including same-day polling places, early voting places, and ballot drop box locations that are accessible to public transportation. Accessibility in this legislation is defined as being within 500 feet from the transportation drop-off point. And in addition, this bill requires that all ballot drop boxes be placed in a way and manner that is accessible to those with disabilities, including wheelchairs. So issues with voting accessibility rose to the surface during the 2020 election cycle in a way that they hadn't even before, although this committee knows I've been working on it for a couple of years in different ways. But in response to specific constituent concerns about the lack of transportation access to proposed polling sites in Baltimore County during the summer, several of our colleagues and I sent a letter to the Board of Elections of Baltimore County with suggestions of alternative sites which had been previously approved and had been used as polling places as recently as the last election, that were actually located on public transportation routes and very easily accessible, both for those who were aging and those with disabilities, and just those of us who don't have easy access to our own cars and transportation. So unfortunately, these suggestions were ignored. And in some districts, including my own in District 42B, we actually had no polling places, early or same day, or drop box locations accessible by public transportation to our voters, even though there were appropriate sites available. So I introduced this bill as a statewide bill after hearing of similar concerns in other jurisdictions such as St. Mary's, Howard, and Montgomery counties. So in addition, several members of the community contacted me with concerns about the placement of the ballot drop boxes that were set up on curbs and were not reachable to those in wheelchairs. And you'll hear from one of those constituents today. This bill requires, also very common sense, simple, and doesn't cost anything, that these be placed in a manner that can be reached by all voters. So all of us on this committee, all of us, regardless of politics, are in agreement that every legal vote should be encouraged and be counted. And to disenfranchise those who require public transportation and disability accommodations is contrary to the spirit of civic engagement and democracy. And so for these reasons, I ask for a favorable report on House Bill 493. Thank you very much.
Thank you. Thank you, Delegate Guyton. Any questions for our colleague? All right, seeing none, we do have a few people signed up. I'll start with Crystal Peters.
There. Can you hear me?
Yes, we can.
Thank you to the committee for hearing HB 483 and to Delegate Guyton for introducing this bill. I am a volunteer with Represent Maryland, an all-volunteer grassroots group who fights for democracy at the local and state level. And one of the issues we work with is on equitable voter access. The year 2020 was a wild ride that taught me a lot of lessons. One of the things that I was reminded of is the importance of protecting everyone's right to vote. While we all know that voting is a civic duty, many people do not think about what the voting experience of others who are different from them is like. This year, I was reminded that not all voters have the same easy experience that I do when casting my vote. There are a lot of voters for whom voting is a burden because their needs for access aren't considered. Imagine being told voting is your civic duty, but then having literal physical barriers to casting your vote. I and Represent Maryland believe that we must continually work to break down barriers to voting and consistently consider whether our current rules and laws are inclusive of everyone. This bill will correct some oversights and make voting more accessible to all by putting polling places within 500 feet from public transportation and making sure that drop boxes are accessible by wheelchair, it will ease the burden of exercising the right to vote on many of our fellow members of society. We hope the committee will find this non-controversial bill favorable and move it to the House floor for a vote. Thank you.
Thank you so much. We next have Cheryl Gottlieb.
Hi, I'm Cheryl Gottlieb. I'm also testifying on this bill. And as I mentioned a couple minutes ago, I do have a print-based disability. And so this year was the first time that I chose to get my ballot emailed to me. And I filled it out online and printed it out. And that part of my voting experience worked beautifully. But I went to the drop box that was closest to my apartment, which is at Carver High School in Towson. And that was a very difficult experience for me. I submitted written testimony primarily for the purpose so that it was easier than trying to share a picture on my screen. So you should have a picture of my drop box, which was all the way up on the edge of the curb, so that if you were on the sidewalk, you could very easily reach the side of the drop box, the back of the drop box, but you couldn't reach the drop box at all from the front without having to get onto street level. The drop box placement was perfect if you were pulling up in a car and leaning out your window. My vision issues prevent me from being able to drive a car. And the placement of the school relative to, I'm not sure if it's York or Fairmount that comes out the main street, it's pretty far in. And so the drop box was pretty far in as well, not at a corner, and curb cuts are usually at a corner. So if you were to Google map the placement of this drop box to a bus stop, it is within 1/10 of a mile, which is what this bill is suggesting. But because it's not near a curb cut and I was not aware of that, I had to go all the way to where the drop box was and then turn around and go all the way back out to the street to get off the sidewalk, to turn around and go back to my drop box. I'm somebody who, I do use a wheelchair, but I'm a part-time ambulatory, and I probably could have made one trip to my drop box on foot. I'm very thankful that I wasn't on foot, because if I had to do that all walking, because I can't get on and off curbs, I can't do stairs without railings, there's no way that I could have walked that far, because you're taking, something that is round trip 2/10 of a mile and making it into, 3/10 or 4/10, and that's just further than I can do. So I know that there were good intentions. It's very easy to pull up in a car, but unfortunately people often just aren't aware of things that don't affect them in their daily life. And if Board of Election staff are all drivers, it's just not going to occur to them to do something else unless something's mandated. So I see I ran out of time, and I will wrap it up.
All right, well, thank you very much for your testimony. We next have Christy Demnowitz.
Hello again. Thank you. My name is Christy Demnowitz, Chair of Represent Maryland. I just want to add a couple of things to what Crystal and Cheryl have said. We believe as an organization that voting access should be equitable to everyone, and that means that it might not look the same for every single voter. But in this case, the changes that are requested are not, they're not going to harm or make it hard for anyone, but they will make it a lot easy for some that need it. So we definitely support the changes that are requested, putting polling places closer to public transportation stops, and absolutely making sure that the drop boxes are accessible to people who are not only to people who are walking or driving a car, but to people who reach them in other ways as well. I think that's a really common sense and no-brainer request. And the last thing I'd like to add is that I think that, the Board of Elections has good intentions, like was mentioned, but unless people are looking at these physical activities from many different perspectives, they're not going to see the whole picture. And so in this case, the whole picture, a lot of the picture was missed. So I hope that the Board of Elections will in the future try to look at things more holistically and from different people's perspectives, so that everybody who has the legal right to vote is able to access, to do it physically. So again, we ask for a favorable report on this bill and hope that this is an issue that will be taken seriously and moved forward. Thank you.
Thank you so much. We next have Edward Johnson.
Good afternoon, delegates. Also special hello to Delegate Attar, since I live in District 41. My name is Edward Johnson, and I'm co-leader of the Maryland Legislative Coalition, which is a coalition of over 30 grassroots groups across Maryland with over 30,000 members. We advocate for legislation that meet the goals of our member groups. Last summer, many of our coalition groups wanted to have the coming election in November an all absentee ballot election like the one in June. So I decided to attend the State Board of Elections meeting at the end of July. During that meeting, the Democrats on the board tried to convince the Republicans to agree to have absentee ballot election, but despite Hogan, but being against it. Unfortunately, they failed to convince the Republicans. However, during that meeting, the Maryland Association of Election Officials proposed a creation of voting centers. Upon hearing that proposal, I immediately thought that was a great idea and wanted to stay involved in the redesign of the November elections. I attended all the State Board of Election meetings through the beginning of October, as well as the many local ones in Howard County, Baltimore County, Frederick, Montgomery, Prince George's, and Baltimore City. The Maryland State Board of Elections did an overall great job with the changes in the election between the mail-in ballots and voting centers. I did a post on Facebook on the mail-in ballots that eventually reached 42,000 people. This post was done to inform people of the new method of mail-in ballots, and the post was originally designed by Delegate Courtney Watson. But problems began happening at the local board elections. St. Mary's County, for one, was the first one to present their State Board of Election proposal for voting centers and drop boxes where they would be located. The board asked about one area that was not covered, and SBA was told it was not important. The following meeting, the NAACP of St. Mary's County had filed a ballot complaint of the lack of voting center and drop boxes in that particular area. And one of the areas they cited was the difficulty of transportation to the voting center locations that were selected as one reason cited. The NAACP proposed voting centers in this area, and they were rejected by the local board of elections. SBA suggested putting drop boxes in that area, but that never happened. A big problem happened in Baltimore County. I have been an election judge several times.
I think he's muted, Madam Chair.
Yeah, I wasn't sure if it was my computer or not. Mr. Johnson, you muted yourself about 30 seconds ago. Come on, this way.
Where did I stop? Okay, a big problem happened in Baltimore County. I have been an election judge several times, always in the Coggesville Middle School. After the closing out of the polling place and leaving between 8:30 and 9 p.m., I would pass by the polling location at Petonia Community Center. They would still have a line out the door waiting to vote. I believe one of the reasons for this long line at the polling place was that lack of public transportation to the early voting center in Hunt Valley. The Coggesville area is a dense apartment area of complexes that many African Americans, Hispanic students, and various other international persons, many of them that use public transportation. So when I looked up the locations that the Baltimore Board of Elections had selected for early voting centers, election day voting centers, and drop boxes, none of them were near public transportation.
Mr. Johnson,
yes.
Johnson, can you please wrap up? The time has passed, and I gave you extra time because of the mute challenge before.
I did 3 minutes already?
Oh, yes. Oh, yes.
Sorry. Okay. Anyway, I advocated to the...
At this point, just wrap up. Give us your last sentence or two.
Okay, last section or two is that people with I'm sorry, to ensure the HB is to ensure that county board of elections take account the voting centers need for voting centers and drop boxes to be placed in locations accessible to public transportation where there's public transportation available.
Thank you so much. Andy Culp.
Hi, good afternoon, Madam Chair, Mr. Vice Chair, members of the committee. I think you're going to love me because I'm going to be extremely brief, and I'll say ditto and then give you some good facts about people with disabilities. Just knowing that there are roughly 621,000 eligible voters with disabilities in Maryland, which represent 14.3% of the total electorate. So the disability of vote matters. And this is just a good common sense bill to help, make it more accessible for people with disabilities without imposing additional costs on the state. So with that, we encourage a favorable report on House Bill 493.
Thank you, Ms. Culp. Yes, very, very concise. You win along with Delegate Lutke today with his testimony earlier. But honestly, to all the members, do you have any questions for any of the 5 people who testified on this bill? All right. Seeing no questions, I want to thank everyone who joined us today to testify. I appreciate your being involved with the legislative process, and we will continue working on all the bills that we heard today, and stay tuned to the Maryland General Assembly website to see when the subcommittees and full committee will be voting on issues. At this point, to members, just wanted to ask if there has any if there are any announcements from the subcommittee chairs regarding meetings this week. Anything from Delegate Washington? No. I'm seeing him. I'm not hearing him. I'll ask Delegate Lutke. All right. Let's see. Delegate Patterson.
Hello, Madam Chair. We will have a subcommittee meeting next week. There's only one bill that's ready right now, so wait next week.
Okay, and Delegate Ebersole. All right, also occupied. Delegate Wilkins.
Madam Chair, can you hear me?
I sure can.
Okay, wonderful. Madam Chair, the Election Law Subcommittee will meet for the first time this year, this Thursday, February 4th at 10 a.m. We have several bills to discuss, all of which have passed in some form out of our committee.
I teach a class on Tuesdays at 5 o'clock on women in leadership. I'm not saying anything about the fact that the only subcommittee chairs that were asked the question were the ladies and not the men. I would not be the one to point that out and say that I was ignored by the 3 men. I'll leave that to somebody else to point out. I'll let everyone know that you already said election law. Revenues will be meeting Thursday, I believe, at 11, and local revenues, stay tuned for a time on Thursday, not sure exactly when. Planning to vote in full committee on Friday during that 11 to 12:30 time slot. We do have hearings this Friday. Yes, we do have hearings. I don't suspect that our voting session will be too long, but we do have 4 early childhood bills from last week, plus about another 10 from this week. So just trying to get some out given our move to the floor next Monday and Thursday. So if no one has anything else for the good of the body, I'll see you all on